We're ready to go.
Okay, thank you. Alan, can we go on the record, please? Good morning. Today is the second evidentiary hearing of the Massachusetts Energy Facilities Siting Board in docket EFSB 22-01, Eversource Energy's request for a certificate of environmental impact and public interest for the East Eagle substation. Good morning and welcome, everyone. To start, I want to explain again how to use Zoom today to ensure that everyone can fully participate in this public hearing from the start. We have interpreters who will be translating from English to Spanish and Spanish to English. To select your desired language, click on the globe icon at the bottom of your screen and select English or Spanish so that you can hear everything said today with interpretation as needed. I will give you a moment to do that. For audio-only participation.
I'm sorry, just a moment, please. Okay, thank you.
For audio-only participation, attendees can dial in at 646-558-8656, which is not a toll-free number, and then enter the webinar ID 836-9233-7532. Simultaneous English to Spanish and Spanish to English interpretation will be provided. Please do not check the box that says mute original audio. We recommend this so you can hear the voice of the actual speaker faintly in the background, but mostly you will hear the voice of the interpreter. Dial-in participants will hear the speaker's voice without interpretation, as Zoom does not offer interpretation for dial-in participants. However, all comments made by dial-in participants on this number will be interpreted into Spanish or English. My name is Donna Sharkey. I am the presiding officer in this proceeding and am conducting today the second day of evidentiary hearings. As part of the bench today are other members of the Siting Board staff: Andrew Green, Director of the Siting Board, Joan Evans, General Counsel, and Wayne Wong, Siting Analyst. Please note that this hearing is being recorded by our stenographer, and video recordings of both the English and the Spanish streams will be posted to the Siting Board's YouTube channel for viewing. Please remember our guidelines to use in speaking at this evidentiary hearing. There is a court reporter participating remotely who will transcribe everything said during the hearing. As we are all relying on internet connections or telephones to participate, we could experience some technical problems. Please speak slowly and clearly to allow a speaker to finish speaking before you begin speaking, and to pay attention to the video speaking and my video. I will raise a hand as a sign on my video if I need to interrupt the person currently speaking to ask them to stop. We will begin this morning by discussing certain procedural matters. Is Ms. Miller on the call today? Oh, Mr. O'Brien, you're here. Thank you.
Hi, good morning.
Will you be participating on behalf of Boston Residents Group today?
Yes, Gail will hopefully join us in the afternoon session, but she asked me to be here this morning.
Okay. As you are aware, you had filed a motion to incorporate certain comments from the NOI docket, which the company has not objected to, but has complained about, I guess. I'd like to ask you why you wanted to include those comments as part of the record in this proceeding.
Sure, thank you. So we understand that developing a complete record is really important for decision-making and evaluation, not just for the presiding officer, but for all the parties. And we feel what we had asked to be included or moved to be included is relevant, and we hope to show that as we go forward.
Could you make a statement now as to why you believe those comments are relevant?
Sure. The project context and history and the various materials that we had listed all have, we think, bearing on the question of the certificate. You know, is the certificate warranted? And happy to get into more specific details, but that's sort of our overarching perspective on it.
Well, what I'd like to do right now is I'll take the matter under advisement, but I believe, Mr. O'Brien, we would like a more complete explanation as to why you believe those documents are relevant to this proceeding.
Certainly. I'm happy to go down each one, either now or in writing, whichever is preferred.
If you could do it in writing, that would be fine. Because I don't think there's an immediacy of, unless you have questions of the company's witness regarding
No, we don't.
those particular comments. Okay. Then I would be happy to see something in writing from you or Ms. Miller.
Certainly, we're happy to provide further detail on each one.
Thank you. I also believe on Friday afternoon, we received a motion from CLF and Green Roots with regard to a potential change for that's in the schedule. Ms. Rubin, would you like to address that, please?
Yes, thank you very much. We have two panels of witnesses that had conflicts that we were unable to reschedule, and are asking that we shift the panel of the community panel, Sandra Alaman-Nijar, John Walkie, and Roseanne Bongiovanni, from June 21st to Monday, June 27th, a date that is already scheduled. And then our second panel is witness Brian Chi. We'd like to similarly move him from June 21st to June 27th. And we conferred with various parties and nobody had any concerns about that. So we are hoping that the citing board will grant that request and shift those two witness panels to the last day of hearings.
My only concern is that was originally scheduled as a potential cleanup day. So I'd like to get a sense from you and from the company, I guess, since they're the most likely to have questions for the panel, of potential time issues associated with presenting the panel and offering them up for questioning.
Thank you, Ms. Sharkey. I think at this point, our expectation is that we will have little or perhaps even nothing for those witnesses coming to it at this point. I think we would reserve the right to cross-examine them. Perhaps staff would have questions or others would have questions that might prompt our need to ask questions, but our plans at this point are not for an extensive cross-examination of either the community panel or Mr. Chi.
In that case, we grant that motion. I just want to warn people, to the extent we need to, we will have a long day that day, because I have hearings starting the next day in another case. So, and there's also some limited availability of having a stenographer available because of some other cases at the department. So people can gird their loins if they need to, with the prospect that it may be a longer day that Monday.
And Ms. Sharkey, a suggestion, and I'm interested if Stacy is interested in this, is as we approach the 27th, perhaps get into the middle to end of next week, if everybody has a more specific idea of the extent to which they may want to conduct cross-examination, it may not even be necessary for them to appear, or if they appear, it would be somewhat perfunctory and perhaps a half an hour or an hour overall. I'm just positing that. I think that's a point we could check in on at some point next week and perhaps have a better sense of the time requirement.
And I am perfectly comfortable with that. Thank you, David, and thank you, Presiding Officer Sharkey, for granting our request.
Is there anything else that we need to talk about before we swear in additional witnesses who'll be offering testimony today? In that case, Ms. Cuthan, could you present your witnesses who will be added to the permitting panel this morning, and I'll swear them in.
Ms. Blaine will move forward.
Ms. Blaine?
Yes, it'll be Ms. Engstrom, Mr. Newhall, and Dr. Dunk.
Could those witnesses raise their hands so it's visible in their video, please? Do you solemnly swear to tell the truth in this proceeding? And you have to answer audibly, so you have to unmute.
Yes.
Thank you. Ms. Blaine?
We'll start with Ms. Engstrom. Could you please state your name, business affiliation, and business address for the record?
Engstrom, 247.
Sorry, you're going in and out.
Oh, can you hear me?
I think.
Okay. Erin Engstrom, 247 Station Drive, Westwood, Massachusetts.
What is your position with Eversource?
I'm the Director of Regulatory Affairs.
Do you have a document in front of you that has been marked for identification as Exhibit EV-EE-1?
Yes.
Is that a copy of your resume?
Yes.
What is the purpose of your testimony in this proceeding?
To support the company's petition and application for a certificate of environmental impact and public interest.
And what has been your role on behalf of the Mystic to East Eagle Chelsea Reliability Project?
I've held a variety of roles throughout this project since beginning in 2019, working closely with the City of Boston when I worked in community relations, working closely with government affairs and state legislators when I worked in government affairs, and now our regulators in regulatory affairs.
Were responses to information requests that bear your name in this proceeding prepared by you or under your supervision?
Yes.
Do you have any changes to those responses to offer for the record?
No.
Do you adopt those materials as your testimony in this proceeding?
Yes.
Thank you. Mr. Newhall, could you please state your name, business affiliation, and business address for the record?
Yes, my name is Christopher Newhall. I work for Eversource Energy with an address at 247 Station Drive in Westwood, Massachusetts.
And what is your position with Eversource?
I am a senior environmental specialist.
Mr. Newhall, do you have a document in front of you that has been marked for identification as Exhibit EV-CN-1?
Yes, I do.
Is that document your resume?
Yes, it is.
And what is the purpose of your testimony in this proceeding?
The purpose of my testimony today is to support the company's petition and application for a certificate of environmental impact and public interest.
And what has been your role on behalf of the project?
Since my employment with the company began in 2020, my role for the project has been to manage, develop, and acquire the remaining outstanding environmental permits and approvals for the project, and to represent the company and the project before regulatory agencies and public hearings and other proceedings related to permit applications and other such actions.
Were responses to information requests that bear your name in this proceeding prepared by you or under your supervision?
Yes, they were.
Do you have any changes to those responses to offer today?
No, I do not.
Do you adopt these materials to your testimony as your testimony in this proceeding?
Yes, I do.
Thank you, Mr. Newhall.
Before you begin, Ms. Blaine, I just would recommend to Mr. Newhall, I think his microphone as part of his headphones may be up top and not near his mouth. It may help us hear him better if he relocates.
If I get closer to, actually, the microphone's on my laptop. Is this better if I get closer?
It is.
Yes, thank you.
Dr. Dunk, could you please state your name, business affiliation, and business address for the record?
Yes, my name is Dwight Dunk. I'm a principal with Epsilon Associates, Inc. We're located at 3 Mellon Main Place, Suite 250 in Maynard, Massachusetts.
And what is your position with Epsilon?
I am a principal and co-manager of the Coastal and Marine Sciences practice.
I'm sorry, your sound is not wonderful. I'm a principal and co-manager of
the Coastal and Marine Science practice. Is that any better?
so perhaps.
Dr. Dunk, do you have a document in front of you that has been marked for identification as Exhibit EV-DD-1?
Yes,
Is that document your resume?
yes.
What is the purpose of your testimony?
To support the company's petition and application for a certificate of environmental impact in public interest.
What has been your role on behalf of the project?
I have been asked by Eversource to provide expertise regarding the Chapter 91 licensing of the substation that is subject to review in this proceeding.
Can you describe your educational background, please?
Yes. I hold a Bachelor's of Science in Biology issued from University of Massachusetts, Boston, a Master's of Science in Biology, concentration in Applied Marine Ecology from the University of Massachusetts, Boston, graduate studies in environmental health at the Boston University School of Public Health, and a Doctor of Law and Policy from Northeastern University.
Do you have any professional licenses? And if so, could you please describe them?
Yes, I'm a professional wetland scientist conferred by the Society of Wetland Scientists.
I'm sorry, could you begin again?
Yes. I am a professional wetland scientist conferred by the Society of Wetland Scientists, a certified wetland scientist issued by the state of New Hampshire, and a board certified environmental scientist conferred by the American Academy of Environmental Engineers and Scientists.
Could you please describe your professional experience as it relates to your role on this project?
Yes, I'm an environmental scientist and environmental permitting specialist. I have over 34 years of experience, during which I grew my professional and academic practice, developing interdisciplinary solutions to environmental challenges. While the bulk of my professional experience has been in the Northeast United States, I've managed and supported projects throughout the United States. My primary areas of scientific expertise are in the fields of coastal and freshwater wetland ecology, including delineation, function and value assessment, environmental impact assessment.
I'm sorry, including delineation, function
and value assessment, environmental impact assessment, ecological and wetland mitigation planning, design, and construction oversight, stage 1 ecological risk assessments, and feasibility and planning studies. My permitting and policy expertise focuses on developing and implementing environmental strategies to secure approvals for National Environmental Policy Act documents, NEPA, and state level equivalents such as MEPA, as well as federal, state, and local environmental permits such as the Clean Water Act and state wetland and waterways permits. I have secured Chapter 91 licenses for many water-dependent projects throughout my career. Such projects include submarine cables, water and sewer lines with associated pumping stations, coastal engineering structures, structures such as seawalls, revetments, and bulkheads.
I'm sorry, seawalls.
Revetments and bulkheads, piers, dredging, docks and floats, berths, boathouses, and waterfront parks. In that capacity, I'm very familiar with the rules and standards that DEP applies to projects such as the proposed substation.
Dr. Dunk, were there responses to information requests that bear your name in this proceeding prepared by you or under your supervision?
Yes.
Do you have any changes to those responses to offer for the record?
No.
Do you adopt those materials as your testimony in this proceeding?
Yes.
Thank you very much. We filed and served these three witnesses' resumes this morning, and the witnesses are now available for cross-examination.
Thank you, Ms. Blaine. Based on the schedule, we are going to start off with intervener questions for the panel. Would anyone like to offer to go first?
I'm happy to go first.
Thank you, Ms. Rubin.
Okay. All right. Good morning to the panel. I'd like to start with some questions regarding the Chapter 91 draft license. Is the panel aware of a previous instance of a request for a certificate of environmental impact and public interest that seeks siting board approval, which includes a Chapter 91 license that has not yet been finalized by the Massachusetts Department of Environmental Protection?
Thank you, Stacy, for that question. For that, I will turn it over to Chris Newhall, our environmental expert.
This is Chris Newhall. I think Dwight Dunk had prepared a response to that question, I believe.
Yeah, I would just note as maybe as Dr. Dunk is looking for the discovery response, there was an information request that we addressed this essentially the same question. If he can be referred to that, he can respond accordingly.
Mr.
Yes,
Rosens?
I'm just looking for that information request.
Mr. Rosenzweig, if you know what the request was, perhaps that would help Mr. Dunk find it.
Does either Ms. Blaine or Ms. Cuthan have that up?
Yes.
This is David. I think it's CLF-GR-P-1.
Yes, thank you, David. I just found that. And yes, just like to respond that yes, in docket numbers EFSB 078 and EFSB 13-1, the siting board granted certificates of environmental impact and public interest to Cape Wind Associates LLC and Footprint Power Salem Harbor Development LP, respectively. In docket number EFSB 07-8, the certificate included the equivalent of a final Chapter 91 license, which was the favorable written determination and draft license that had been issued earlier by Mass DEP and had been introduced into the record of the siting board's proceedings. In docket number 13-1, the certificate included the equivalent of a final Chapter 91 license, which was the favorable written determination and variance decision that had been issued earlier by Mass DEP and had been introduced into the record of the siting board's proceeding.
Thank you very much, Dr. Dunk. Can you please confirm that for those dockets that you just referenced, that in all cases, those were draft Chapter 91 licenses that were not yet final by the Massachusetts Department of Environmental Protection?
Can I just ask for purposes of the Dr. Dunk, when you say final, are you saying that they had not yet reached a stage where they were non-appealable and not challengeable in all respects? I mean, maybe perhaps a little more clarity on the word final would help them respond.
Yes, my understanding is that a Chapter 91 license is not considered final until all appeals periods have expired. So I'm asking Dr. Dunk if you can confirm for me whether Mass Department of Environmental Protection had issued the final license, which did not involve any further appeals for those dockets you just mentioned.
Ms. Rubin, I would need to back check the file to answer that fully.
Is that something that you would be able to check and respond later today?
Please let me confer with Mr. Rosenwag on that point.
That's up to Presiding Officer Sharkey.
I would suggest we could address that at a break, and he would be able to respond. I think it's a simple matter.
Thank you.
Excellent. Okay, so let's just come back to that later on after a break. I'd like to call the panel's attention to the Massachusetts Department of Environmental Protection's response to information request EFSB-DEP-2. And if you could let me know if you have that up in front of you, I can then ask the question. Dr. Dunk, do you have that in front of you?
I am looking for that right now in my files. Is EFSB 22-01? Was that the?
So
That's our docket number.
Correct.
Oh, sorry.
So I will repeat again. So we're in EFSB 22-01 is the docket, and I'm referencing the DEP's response to EFSB-DEP-2. And this was filed on May 11th of 2022.
Yes, I have that now.
Thank you. That response says, it is acceptable to Mass DEP for the board to include the draft Chapter 91 Waterways license issued January 3rd, 2022 in its entirety as an approval in lieu of a Chapter 91 license. Do you see that?
Yes.
Has Eversource or the consultants had any communications with Mass DEP about the Chapter 91 Waterways license since filing this petition and application in the current docket?
This is Chris Newhall. I can answer that question. The company has not had any communications with DEP related to the Chapter 91 license since the filing of the petition request in February.
Thank you, Mr. Newhall. Has Eversource ever had any communications with Mass DEP about the relationship between the Chapter 91 license application and a certificate of environmental impact and public interest?
This is Chris Newhall. I can answer that question as well. And the answer is no, we've not had any communications with DEP related to that.
Thank you. To the panel's knowledge, has the Department of Environmental Protection issued a water dependent use determination for the proposed substation?
Yes, the department issued a determination that the substation is an ancillary facility to the licensed Chelsea Creek Crossing, license number 12943, which are electric cables under Chelsea Creek. Those cables were determined to be an infrastructure crossing facility, which is a water dependent use. You may see Ms. Hops's written testimony.
Thank you. And can you please point me to an existing document in the record where that water dependent use determination is indicated?
Yes, let me just identify that. I believe the letter from the attorneys, Keegan and Werlin, dated July 23, 2020, which is the response to public comments on the Chapter 91 license, identified the 3 instances in which the DEP identified that the project was duly determined to be a water dependent use. And those were the public notices for public comment, as well as the draft license itself.
And Dr. Dunk, in your extensive experience working on Chapter 91 license matters, is this type of indication in the public notices you just mentioned similar to how a water dependent use determination is made by DEP in other instances?
For water dependent uses, let me just pull up my notes here. I'm just yes, in I believe it's section 912.
I'm sorry, is that 912?
310 CMR 9.12. The department, in the cases of an infrastructure crossing facility or any ancillary facility thereto, for which an EIR is submitted, the department shall find such facility to be water dependent.
I appreciate you, Dr. Dunk, citing to the relevant regulatory position. I instead want to ask if you've seen a similar fact determination pursuant to that regulatory provision that has been made in a different proceeding involving a Chapter 91 license. Is that similar to what happened in this matter?
Yes, in my experience with many of or I would say all of my water dependent use projects, I have not seen the department issue a separate written determination on the water dependency of such projects.
Thank you. Is there a functional relationship between the proposed substation and the licensed Chelsea Creek crossing?
Yes, I would say there is. I would defer to the engineers at Eversource for the technical interrelationships between these two projects. However, as an environmental scientist and permitting specialist, reading the regulations and the record, the department made the determination that the project meets the definition of ancillary facility, as noted in Ms. Pops's testimony. So the department interpreted the regulations to do so. The plain language of the definition in the examples therein identify facilities that are required to interconnect related facilities. And those examples are structures, facilities that refer to changes in power, volume, pressure, or traffic. When we read the definition of infrastructure crossing facility in 9.02, it is any infrastructure facility which is, and just as the first one of the
I'm sorry, any facility which is, and I couldn't hear what you said.
Which is, and they give several examples, one of which is a cable, and then it continues, which is located over or under the water, and which connects existing and new infrastructure facilities located on the opposite banks of the waterway. It further reads any structure which is operationally related to such crossing facility and requires an adjacent location shall be considered ancillary facility thereto. Such ancillary facilities include, but are not limited to, power transmission substations. So it identifies a power transmission substation as an ancillary facility, and therefore there's that. And then, as I was explaining, these types of ancillary facilities, which are considered operationally significant or operationally related, are where the operations of those crossing facilities need to interconnect with other pieces of infrastructure. So those are would include and include the power transmission substation, gas meter stations, sewage headworks and pumping facilities, approaches, ramps, and interchanges to adjacent highways. So
Dr.
those
Dunk,
are all items that interrelate. So based on my experience, the electrical substation, a power transmission substation, is operational related to the Chelsea crossings.
thank you, Dr. Dunk, for your very detailed response. Also, Stacy, I just want to refer you back to, I believe it's CLFP7 that has a written response to this that we answered in an IR. David Petersile, I know you had some additional information to add to Dr. Dunk's response.
Yes, Stacy, thank you for the question. In addition to the IR that was just referred to by Ms. Bowden, information request EFSB G6 further describes the interrelationship of the Chelsea Creek crossing to the new substation as it relates to the determination for water dependency question under the Chapter 91 draft license that was issued by DEP.
Thank you very much. Is the panel aware of a different facility, the Weymouth Compressor Station, which involved a Chapter 91 license and recently received a court decision from the Norfolk Superior Court on May 2nd, 2022?
Yes.
Thank you. And in that particular case, would you please describe, Dr. Dunk, what the court's finding was with respect to the Chapter 91 license in that matter and its relationship to an ancillary structure?
If I could just comment, Dr. Dunk may be able to provide his understanding of it, but he is not a lawyer, and the issues there were legal in nature. A judge issued a ruling. I'm sure the parties to that proceeding will be following up as a pending legal matter. So I'm not sure how much he can add to that, but he can provide whatever level of understanding that he has.
Thank you, Mr. Rosenzweig, and that's all I'm asking for is he clearly has expertise in this issue and has worked on numerous licenses, and so I'm just interested in his perspective.
In terms of the recent court decision, as Attorney Rosenzweig said, that I am aware of the court's decision. I understand that it was remanded to the department and that there have been briefs filed, and I have not yet seen those briefs. So I could respond further after I have a chance to review those briefs.
Thank you very much. And Dr. Dunk, you referenced that you would defer to engineers at Eversource for a more technical explanation about the relationship. I just wanted to see if any other panelists wanted to respond to provide further information.
Yes, Mr. Rubin, this is David Petersile again. The technical information I think you're requesting is in the response to EFSB G6. And to summarize, fundamentally, the existing underwater Chelsea crossing provides the connectivity of the transmission line to the new proposed East Eagle substation. As previously described, the existing transmission line only interconnects Mystic Station 250 to Chelsea Station 48. But under the original underlying proceedings, for this particular substation, the intent was to bring transmission to East Boston as a critically needed transmission infrastructure, step it down to distribution utilization voltage, and then distribute it to the residents of East Boston.
Thank you, Mr. Petersile. I appreciate that. I'd like to turn now to some general matters for which the certificate petition has been filed, so no longer on Chapter 91. I'd like to refer the panel to Eversource's response to CLF-GR-G-2. And in particular, I'm looking at page 3. In the first full paragraph, Eversource states that the energy and environmental benefits of the substation greatly outweigh the minimal impacts of the substation, even considering existing environmental burdens in the community. Is it Eversource's position that in addition to the asserted net positive impact on the host community, the substation also ensures the equitable distribution of energy and environmental benefits and environmental burdens as between the host community and other communities?
Thank you for that question, Stacy. I think we're going to have a few people answer, but I think I will start this question with Craig Hallstrom as our President of Electric Operations.
Sorry about that. Well, so the East Eagle substation is being built for the kind of the sole purpose of supporting the community of East Boston. That's why it's being built. And that's its purpose, and the community of East Boston will benefit from that substation.
Thank you, Mr. Hallstrom, and thank you, Ms. Bowden, for also playing the master of ceremonies of sort. Are there others who want to respond and add to this question?
Ms. Rubin, this is Meredith Baraka. As we referenced in our response, we also feel that it's not an overburdening of the community with electricity infrastructure that now exists, and that's on page 4 of the response you reference. A substation in East Boston will ensure continued reliability of electric service in East Boston and allow the residents of both East Boston and Chelsea to fully participate in the electrification goals and all of the objectives we're trying to meet with reducing emissions in Boston and in the Commonwealth.
Thank you, Ms. Baraka.
And I'll just add that in addition to that, on page 4 of the response, as well as on page 5 of the information request, we begin to talk about the benefits of the community benefits agreement that we had with the community directly, East Eagle Hill Civic Association, as well as the Salesian Boys and Girls Club of East Boston. And
I'm sorry, as well as the what?
Salesian
Oh.
Boys and Girls Club of East Boston. And all of those outcomes of the community benefits agreement directly enhance both the environmental and energy benefits that the community of East Boston will see as a result of the substation.
And I may also add that the proposed substation site was a contaminated site that Eversource conducted significant remediation to remove almost 10,000 tons of contaminated soil from this location, as well as hundreds of thousands of gallons of contaminated groundwater on the site. We did that at our own cost and to prepare the site for the substation, but overall, that is an improvement on the what were the existing conditions at the site.
Thank you. And a follow-up question, Mr. Newhall, based on what you've just shared. Is there additional remediation that Eversource intends to do if you get the approval from the siting board to move forward?
A moment, I can pull up kind of the status of our remediation there and respond more appropriately.
Of course.
Having some trouble locating that at this time. If we could, I guess, do a
Chris?
records request. I can.
Actually, Chris, I'm going to have Meredith Baraka jump in to talk a little bit about the East Boston area and our CBA agreement and the remediation and different upgrades we'll be doing to the area there. Go ahead, Meredith.
Thank you, Nicole. To provide some additional specifics for the mitigation that Eversource is working with the community on. So as Erin noted, we are providing more than $1 million of mitigation to the East Boston and specifically the Eagle Hill neighborhood in the form of additional trees, upgrades to the urban wild, working in hand with Boston Parks and Rec and the Eagle Hill Civic Association, providing for a fund to increase the tree canopy in East Boston, which we know has the lowest tree canopy in the entire city of Boston. And as Erin said, installing upgrades in energy efficiency at the Boys and Girls Club. In addition to that, we have been actively working with the Eagle Hill Civic Association as well as other members of the community on improving the aesthetics and of the facade for the substation and making sure that it is in harmony with the surrounding landscape and the surrounding streetscape, so that the goal would be that if you're passing by, you don't even know what is behind this facade, as we have done throughout Greater Boston with many of our facilities.
Thank you, Ms. Barica. That's very helpful. I don't think I got an answer to my question about whether additional mitigation and remediation was additional remediation was planned.
At this time, I do not believe we have additional remediation planned. I believe we have some groundwater monitoring for the site, but at this time, no additional remediation planned.
Thank you.
If I could interrupt for a minute, Mr. Newhall, did you select a language when you signed into Zoom?
Yes, I did. I selected English.
Okay. So maybe we were speculating as to why that was, you were having some audio problems. If you could just lean in closer to your screen when you're speaking, that'll help us and the recording.
Certainly, I apologize for poor audio.
Nope, not a problem. Sorry to interrupt, Ms. Rubin.
Thank you. We are doing the best we can with technology limitations. A follow-up question, are ratepayers paying for the remediation that has already been described as the removal of almost 10,000 tons of contaminated soil and treatment of thousands of gallons of contaminated groundwater?
Erin, do you want to take a stab at that as our regulatory expert?
I'm going to have to defer to council. I'm not aware of this.
Stacy, if you want, we could take that as a record request and get some input from our rate making folks who aren't really part of the panel.
Sure. Let's make that a record request, please.
Then I believe that would be record request CLF-GR-3.
Thank you. Do any of the panelists live in East Boston?
Although I live in an environmental justice community, I do not live in East Boston.
I also do not live in East Boston.
I'm sorry, I couldn't hear who was speaking.
It was Mr. Newhall, I believe.
Okay.
I do not live in East Boston. I do not live in East Boston.
I do not live in East Boston.
And I do not live in East Boston.
I do not live in East Boston.
I do not live in East Boston.
Nor do I.
Why, Juan Martinez?
Mr. Zico, maybe you could repeat that because I don't believe your answer showed up in the transcript.
Thank you. Yes, I do not live in East Boston.
Thank you. I think we heard from all of the panelists. So I want to stick with the information request CLF-GR-G-2. And in particular, I referenced the section earlier about the distribution of benefits and burdens. And the response from the company suggests that even considering existing environmental burdens in the community, it still finds that there is compliance with the roadmap law. Is it Eversource's understanding that in addition to whether the substation adds to existing burdens in the community, Eversource and the siting board need to assess whether the substation has an impact on the disproportionate burdens currently being faced by East Boston residents as compared to other communities?
point there is essentially you're asking a legal question of what the siting board is required to do. I don't think our witnesses are in a position to respond to that. That is something certainly all the parties could brief, including us and CLF and others. But as to what the siting board is required to do to comply with the roadmap law, and this is, I think, indicated in the outset of the answer, that is essentially a legal question.
Thank you. I do believe that the panelists can respond to Eversource's position on that.
Well, I don't know that they can. I think they have explained elements that they believe would contribute to a siting board finding if one were required, but I don't think they have testified in any manner as to what is required by the roadmap law.
I believe all 8 pages of the company's response to CLF-GR-G-2 is Eversource's position on whether it needs to comply and has complied with the roadmap law. So I'm just asking a further question to clarify the content in the response to that information request.
This is Chris Newhall, and I can jump in and answer at least, I think, part of that question. So it's our understanding, obviously, that the roadmap law applies to the Executive Office of Energy and Environmental Protection agencies and not necessarily directly to applicants for projects. The only regulatory frameworks that I'm aware of where such requirements are put to applicants to assess within a permit application is through the Massachusetts Environmental Policy Act office and their recently adopted protocols for addressing environmental justice considerations in those applications. And I will state that the project as proposed in the Chelsea Creek crossing was not subject to MEPA review through filing of an environmental notification form.
Thank you, Mr. Newhall. Going back to the assertion that the benefits greatly outweigh the minimal impacts, is it Eversource's view that the people and families who will be living in the vicinity of the substation see the impacts of construction and operation of electrical substation as minimal?
What was your question, whether the company believes it's minimal or whether certain residents in the community see it as minimal? I may have missed part of your question.
I'm going to just repeat it. So is it Eversource's view that the people and families who will be living in the vicinity of the substation see the impacts of the construction and operation of an electrical substation as minimal?
This is Chris Newhall. From an environmental protection standpoint, as a company, we've done everything that we feel is necessary to minimize our impacts related to impacts to the environment and, for construction related impacts. But I wouldn't be able to speak to, the perspectives of the local abutters in this regard.
And I'll just add that in regards to our filed information request, that was specific to the environment and energy disruptions as opposed to construction disruptions.
I think Mrs. Baraka said it best in the beginning. We want East Boston to be in a position to join the electrification and the efforts that the city of Boston is putting forth. And so this substation is the only way for that to happen. With that substation being built, however, Mrs. Barraker and I have been working with the community on the facade design for the substation to ensure, although the substation is here, it still fits the aesthetics of what's currently there now and what's to come with the BPDA's initiative to bring that specific section of East Boston to a more modern look, to get it away from the sort of industrial look that's there now. We want to align with the look of the police station, and we're using and soliciting feedback from everyone in the community. So anyone who's willing to come and participate, we've sent the invite to many folks. We want the open dialogue and participation, and that substation fence will be an example of us working collaboratively with the community to mitigate the views of that substation.
And I would just add, because you asked about operational impact. So once a substation is built, the impact of day-to-day operations is very minimal or insignificant. There's no heavy vehicles involved. Our station operating people drive small van type vehicles. So from a day-to-day perspective, not a lot of impact and not a lot of traffic, not a lot of heavy vehicles, that type of thing.
Thank
And
you.
Ms. Rubin, this is David Peterson. I can also offer your reference to EFSB G3, where I believe that's where we document and all the prior proceedings relevant that the project has addressed environmental protection, public health, public safety in relation to the public interest and necessity that's being discussed today.
Thank you.
The last thing I'll add as well is that this location in particular allows that transmission lines will not need to be constructed in the city streets to interconnect. And we understand that construction, though temporary, is disruptive to residents. And so this location specifically minimizes in-street construction for the residents of Eagle Hill.
Thank you for that comprehensive answer. I will have further questions on some need issues that I'll save for a subsequent panel and follow up to Ms. Bowden's point earlier. Eversource asserts that the impacts of the substation are minimal, but isn't it true that there are possible uses for the property on East Eagle Street, which would have fewer impacts?
Ms. Rubin, what specific uses are you referring to exactly?
There could be numerous other uses for this property, such as a recreational location. Wouldn't that have fewer impacts than an electrical substation?
Before we purchased this land, I would just add that it was a brownfield. And as noted earlier, we did remediate over 10,000 tons of soil. So we can't speculate as to what it could be, but what has been approved in 2 proceedings is the use to build a substation.
Yes, to follow up Ms. Engstrom's comment. So, per the administrative consent order that's attached to the property by DEP, there most likely, even post remediation, will be a limited use requirement. And Chris Newell could probably describe better what a limited use requirement would be. And
I'm sorry, I just couldn't understand that sentence. And so what?
Chris Newell can describe best what the limited use means. However, my understanding is a limited use would preclude it because it's historical contamination history. Even post remediation, there would be minimal or limited uses that the site could be allowed for. So the consideration of it being a park, for example, may not be a particular use that might be allowable under the state DEP guidelines. If that's what you're asking, I'm surmising with the question.
And I will jump in and provide some additional response to Mr. Petersow. So this property was acquired by Eversource through a land exchange with the city of Boston. So it is now private property. That was in exchange for private property elsewhere in East Boston, for which the city sought to build their library, their public library. So this was a land swap that is, the property is now private property to build on what Mr. Petersall said and what Ms. Engstrom said. The site was a brownfield, and the remediation costs for the city were prohibitive. Eversource has taken on those costs to remediate the site, such that now it's not considered to have any soil concentrations of contaminants that would pose any potential risk to human health, either during construction or operation of the substation. However, the site would have an activity and use limitation imposed on it by DEP. And those types of activity use limitations would more or less prohibit any type of use of the space for green space or other recreation, such as a park, that would be imposed on the property unless further remedial activities were conducted on the property by some entity.
Yes, I would also like to add that the site is located within the Chelsea Creek designated port area, referred to as DPAs. DPAs are sites that have historically supported industrial uses and are designated by the state to kind of keep those sites in industrial use. And, therefore the, state regulations and state policies is to, with the designation of a DPA, is to kind of, hold aside these properties within these areas for water dependent industrial uses.
Thank you all. Is the panel aware that the nearby Condor Street Urban Wild, one of the few green spaces in East Boston, the history as to whether that was previously a contaminated site?
I do not know the history of the adjacent Condor Urban Wild site.
Nor do I.
Nor do I.
Nor do I.
Unfortunately, I do not either.
I do not.
I do not, but I've had extensive conversations with the community in Eagle Hill, specifically regarding the urban wild and how they feel as though there needs to be much more done to improve the current quality of the urban wild. And in fact, as part of our community benefits agreement and through that negotiation process, we learned a great deal about the history of the urban wild, and what the community would like done to the urban wild is definitely significant improvements, specifically potentially expanding the urban wild away from our site in particular. And, as part of that, we had discussions. We developed a community benefits agreement to put a significant amount of money towards improving the urban wild in the Eagle Hill community.
Thank you very much. Is it Eversource's position that the original land swap that resulted in the land disposition to allow Eversource to consider the current site, whether that was a transparent process?
Thank you for that, Stacy. I'm going to start, and then I'm probably going to have David Petersall jump in. We use the term land swap, but that site actually had to go through a requisition, as I believe, David. It's put out to bid, and folks, anyone is allowed to come in and bid on it. Eversource was the successful bidder, and then acquired the property, where we sold our existing property on Bremen Street to the city of Boston to become the beautiful public library that's there today. David, jump in and correct me if I've misstated anything.
You're absolutely correct. It is entirely public process. The city of Boston has to advertise for any disposition of city-owned property, and numerous potential purchasers can make a purchase offer, which Eversource did. Everything is fully recorded in the Suffolk County Registry of Deeds. And in the underlining notice of project change proceeding, all the relevant documentation associated with the purchase and sales agreement and those recorded instruments were provided.
Has Eversource attempted to quantify the amount of benefits and burdens relating to the substation, either in financial terms or otherwise?
In our response to CLF GRG2, I believe Eversource summarizes our views on both the environmental and energy benefits in relation to this project.
And I would add to Ms. Engstrom's answer, as she stated in CLF GRG2, we do apply a monetary value to the community benefits agreement that was negotiated with the Eagle Hill community, both the Boys and Girls Club and the Eagle Hill Civic Association. So those dollar values for what we can put a dollar value against are cited. And I would also add that there are non-monetary values that we also are also part of the community benefits agreement, including such things as providing an basic curriculum on the underlying science of electricity for the Eagle Hill and East Boston residents, which will be translated into the appropriate languages. Also providing outreach and educational materials to the East Boston community on initiatives related to green energy, renewable energy, especially in a high rental area. Offering and providing direct marketing in East Boston and Eagle Hill regarding our Main Streets energy efficiency program, and also offering to residents and to residential customers home energy audits and some of the other items we offer for residences as opposed to businesses to improve energy efficiencies in the homes.
And I'll just add that specifically to in regards to the Salesian Boys and Girls Club and the energy efficiency benefits that will come from those projects, while it may not be specifically a monetary value that we've included as part of the CBA, there will certainly be significant savings that the Salesian Boys and Girls Club will experience from an energy savings perspective, given the upgrades that we will be making.
Is it fair?
I'll just further add that the cost of the remediation that's been conducted at the site to date is approximately $4.7 million. That cost, again, has been borne by the company. And if there was an effort ever to remediate the site by the city of Boston, that cost would have been borne by the city as opposed to a private company.
Thank you very much. Is it fair to say that Eversource's weighing of burdens and benefits is more qualitative than quantitative?
I'll attempt. Electricity is a right to everybody that lives in East Boston, and leaving anyone in that community, whether they're young asthmatic children, older grandparents, without electricity for any amount of time is not something that Eversource will ever do. This substation is necessary to keep that right to all of those folks there in East Boston. And
I'm sorry, this substation is necessary to keep that right. What?
To all of those folks in East Boston. And so when weighing the burdens on the community, the bigger burdens being without power for any amount of time. With that, I'll turn it over to Craig to just talk a little bit more about what that burden looks like, losing electricity for any amount of time there to those residents.
Well, thanks, Nicole. I mean, I would agree with you. I mean, I think we all know what, not just frustration, but risk of life, risk of property, especially during the most extreme, weather events that we may have. So, the cost of not having energy is significant. And that clearly is, the reason that I want to build this substation, because it's needed to supply the area with reliable and resilient power. So, I think when you think of cost, the cost of not having power is probably the greatest cost of the things we're speaking about.
Thank you. And just to follow up on the reference to the $4.7 million of cleanup costs, is that embedded in the total project cost for the substation?
David or Chris?
I was going to say that's probably a question to me. I would need to check with our cost estimators to determine if that number had been folded into the overall project cost. So I do not have that information readily available.
Actually, that I'll take that, Chris. So the answer is it is, and it was addressed in a notice project change. In the notice project change, I believe there's a question. Give me a minute and I can find it. In the underlying notice project change final decision on page 77, you can find the descriptions of what cost elements were in the original estimate and what elements were identified as additional costs to the project, one of which at that discussion was the remediation effort, and the other was the additional re-engineering that was necessary due to the relocation of the site within the total city parcels. So in the current project estimate, and I believe it's roughly 66 million, that 5.7 is contained therein. However, I guess we'd have to determine, and maybe someone else like Craig Hallstrom could identify if it's if that ends up being a cost that, I think you asked this earlier, is this a cost that gets commuted to ratepayers? And that I'm not aware of. But I think that was an earlier question.
And we have a record request for that, David. So I think if we continue to stay on track and answer that through the record request, that would probably be the best.
Okay.
Thank you. I just want to make sure I understood what you just said, Mr. Peterseil. So you mentioned that the underlying project change filing decision from the siting board states that the $5.7 million was a separate cost from the project, but then I thought I heard you say that that's embedded in the total $66 million.
Yeah, the current, again, I refer you back to that document. The $66 million includes that 5.7 for the project cost estimate at that time.
Thank you.
Just to clarify, David, you meant the 4.7.
I'm sorry,
5.7.
I apologize.
4.7, got it. In determining what is burdening or not burdening the East Boston community, how did Eversource consult with the host community, recognizing that there are multiple entities within the host community?
Meredith, you and I can probably tag team this one if you want to start talking about the meetings that we've had with the various community members dating back to, I believe, early 2010s.
Thanks, Nicole. Yeah, I was just going to say throughout our process, and this is going back now to 2014, Eversource has sought, key community and elected officials who have additional reach within their own networks as well to help communicate with their constituents, information about the project and opportunities to participate in community meetings. We have throughout our process, throughout the years of this project, worked with key stakeholders and local agencies and local elected officials to keep people appraised. Like I said, I think we're going on 8 years of various outreach activities with myriad number of groups and individuals. And some of those are detailed in EFSB G10 as well.
And just to add to your statement, Meredith, even dating back to early 2000s, we began working with the city of Boston, who's the biggest advocate for East Boston as it's a part of their city, and working on our need for this substation, working with them on different community outreach and who we should be speaking with, and talking to, including, like Meredith stated, city councilor for the area. We also have been working with other elected state officials. And so it's been quite some time that we've been collaborating with all of these different stakeholders, dating back to early as 2008 when we began our Bremen Street land swap, as we call it loosely.
And I will just add that throughout the last, we'll say 8 years, as Meredith had stated, we've continued to listen to the community and hear what their concerns are. And we've made every attempt possible in both filings, as well as a part of this petition, to make sure that we do address the main concerns that are coming from the communities that we heard.
In hearing those concerns from the community, did the company consider moving the proposed substation to a different location in East Boston, not on East Eagle Street?
Could you give me a time frame? Are you saying in the last year, or at the outset when it went through its initial site selection process? Just a temporal aspect will help the witnesses know what you're asking.
Sure, I'll ask it in two different parts. So we'll start from 2008 through 2021, when there was a decision from the siting board on the project change filing.
So your question is whether the company investigated alternative sites before arriving at the location at the city parcel as part of its review and proposals to the siting board. Is that what you're asking at this first piece?
That is correct.
Okay, I can take this one. So as we stated in CLF GRG 32, there is no viable alternative site, and the company did go through extensive investigations looking for any potential sites for this potential substation. This is where we ended up at the current location, because it achieves both the best balance of the siting board's statutory criteria of reliability, environmental impacts, and costs. And the siting board found in both instances that the company's site selection process and the company had not overlooked any alternative sites that would be clearly superior to this.
Thank you. Oh, Ms. Bowden, do you have more to add?
I was just going to say, alternatively, and the underlying case, condition K, required us to look at the existing parcel, and we did that in working with the city. We also outreached to certain groups, including Green Roots, as we begin that selection process to move it on the current parcel, and had conversations with that group as well.
Thank you. Since the enactment of the roadmap law that we have been discussing this morning, has the company considered choosing a different location for the proposed substation?
So just to help the witnesses, Stacy, because you know more about those particulars in terms of timing, when you talk about the enactment, are you talking, can you give them a particular date, or roughly speaking, a particular date when the roadmap law became effective?
Yes, since the end of March of 2021, that was the time when the roadmap law was signed into law.
So I probably sound like a broken record, but again, this substation has been needed for quite some time now. And we need to get this substation constructed and online to provide the essential electrical service to those folks in East Boston. So since that roadmap law has been enacted, our focus has been constructing and putting the substation online, not moving the substation to any other particular parcel. I keep saying this, and I go back to Craig Hallstrom, our president of electric operations, just to talk about the urgency and extreme importance of getting the substation constructed and online. And that is our focus at this time. Craig, anything additional?
Oh, I'll continue the broken record theme. We've talked about the need. We've talked about, the Chelsea substation 488 reaching its maximum, and we've talked about loads, and I know we're going to talk probably more about forecasts and loads, but we're at a point where this station, needs to be built. Without this station, the people in this area, both East Boston and Chelsea, are at risk of having their service interrupted. And I think we're at a point where we've gone through the process. We've gone through our rationale of this site versus other sites, and that rationale has been accepted in the prior parts of this docket. And we believe and continue to believe this is a very good site for this substation. It minimizes impact of, and it was brought up earlier, it minimizes impact of construction and expense, and the benefits, in our opinion, certainly outweigh any offsets.
And just to refer you back, CLF GR G34, we did answer this question in written response, but just to kind of add on and close out this question, EFSB approved this location in February 2021. Again, our main focus now is to finalize our permitting, which we've been doing for the last year or so, maybe even a little bit more, and get into a construction mode and get to a point where we're putting this station online.
Thank you. I'd like to turn the panel's attention to the company's response to CLF-GR-G-8.
If I could just interrupt for a minute, Ms. Rubin, are you moving to a slightly different line, and so would it be an appropriate place to take a break?
Yes, it is slight. It is still related to environmental justice, but I'm more than happy to pause so that we can take a break.
Okay. Let's take our morning break right now and come up back at
Maybe we take 15 minutes.
yes, Mr.
Thank you.
Brock. So that would be 11:45. Thank you, everybody.
Donna, we're off the record, correct?
We are.
I did say at the outset of the hearing, there was a question from Stacy that we would confer during the break. And if Stacy wants to re-ask the question, Dr. Dunk would be prepared to respond at this point.
Okay, thank you.
Stacy, I think Mr. O'Brien also has his hand up.
Oh, sorry. Mr. O'Brien?
Yeah,
you
hi,
like-
just briefly, yeah, we citizens group do have some questions. So I just want to make sure maybe 20 minutes, 30 minutes worth, just so we can proceed in an orderly way.
Sure, thank you. Alan, why don't we go back on the record? Ms. Rubin, would you like to resume your questions? And I appreciate your letting us go take a break.
Absolutely. Thank you. Just earlier this morning, there was a question where we had asked the panel if there was some information that they would be able to provide, and the response was that they could do so during a break. Is there more information that the panel can provide at this time?
Yes, Ms. Rubin, that question was regarding the status of the footprint power and Cape Wind licenses, correct?
Correct.
Okay. Yeah, in both those cases, the department had issued draft licenses, so they had completed their administrative review, such as in this case. And in both cases, the draft license was included as part of the EFSB certificate, which is the request by the company in this case as well.
Thank you, Dr. Dunk. Can you just confirm that the appeal periods for those two matters had closed prior to the siting board review?
They would have been subject to appeal after the siting board certificate was issued.
Thank you. Okay, I'd like to turn the panel's attention to the company's response to CLF-GR-G-8. And here this is referencing the Massachusetts Executive Office of Energy and Environmental Affairs Environmental Justice Policy. In the company's response, Eversource states that the EJ policy sets out provisions for public participation and analysis of impacts and mitigation in siting board proceedings. Eversource also states that the process undertaken by it and the siting board in this proceeding are in full compliance with the EJ policy. Can the panel point me to where in that analysis of impacts and mitigation as required by the EJ policy are in either the petition or other parts of the record?
Can start with that one, Ms. Rubin. And I would say there's a couple of components to this, but specifically for public participation and enhanced outreach, we have worked with public comment hearings via Zoom. We have ensured translation of all of our materials. We have been continually working with the community and made sure to be listening to what they're saying. So frequently, many large infrastructure projects, Eversources and others, are met with opposition. And acknowledging we are listening, even if we disagree with the conclusion of the opposition, I think is what we strive to do. And that is evidenced by the conclusions that or the negotiations we came to with our community benefits agreement. Those items that Ms. Engstrom had referenced earlier this morning, we're community driven. The parties that we've been working with on the design of the enclosure are residents and officials who know the community best. And we are working hand in hand with them to make sure that we're taking our cues, and have been throughout this process, from the community members who live and work in the Eagle Hill neighborhood. The last thing I think it's important not to overlook is making sure that we are providing the keys to unlock electrification within the East Boston and Chelsea community, which will also enhance and benefit both of those neighborhoods.
Thank you, Ms. Barica. You just referenced the community benefits agreement with the Eagle Hill Civic Association and Salesian Boys and Girls Club. Are the costs of the community benefits agreement included in the $66 million project cost?
I believe David Petersile may be able to answer that.
You can refresh my memory as to what the question was. I apologize.
Sure. I'm asking if the costs that are included in the community benefits agreement between Eversource and the Eagle Hill Civic Association and Salesian Boys and Girls Club are included in the total $66 million cost of the project.
So that community benefit agreement was developed after the notice project change, and therefore after the publication of the $66 million cost estimate, and therefore would not be included in that $66 million cost estimate.
Thank you. And would the costs to comply with the community benefits agreements be passed on to Eversource ratepayers?
I believe we have an IR out for a similar question that we can probably include this response in that IR as well.
If we want to include this as part of the record request CLF 3, I would be amenable to that, if that works for Presiding Officer Sharkey.
You're on mute, Presiding Officer.
If that works for CLF, then that is fine for us.
Yes, absolutely. Does the panel understand the question?
We do, but if you want to rephrase it or restate it for just clarity in the record.
Sure. We're trying to understand whether the costs of the substation, the $66 million, is passed on to ratepayers versus paid for by shareholders, and the additional costs to comply with the community benefits agreement are also paid for by ratepayers or paid for in other ways.
Understood. Thank you.
Thank you. Let's turn now to the company's response to CLF-GR-G-19. In this response, Eversource indicates that the petition and application complies with General Law, Chapter 164, Sections 69K through 69O, and with 980 CMR 6, and that these items do not establish particular requirements for a specific showing in the petition and application. I want to turn to the requirement in Section 69O that the facility be compatible with considerations of environmental protection. Is it Eversource's position that the company was not obligated to present the siting board with an assessment of compliance with the roadmap law and EJ policy as considerations of environmental protection?
Are you saying during this proceeding or in the petition or application? What's your question?
In the petition and application.
So in the petition and application, I might have to check my dates, but the roadmap law and environmental justice policy were not part of that proceeding based on when they became into effect. Regarding this proceeding, yes, we do believe that we took those into account.
Thank you. Is Eversource aware that the roadmap law defines environmental justice principles as principles that support protection from environmental pollution and the ability to live in and enjoy a clean and healthy environment?
Yes.
Given the history, the long history of this project before the siting board, including concerns expressed by residents of environmental justice population, wouldn't the host community and the siting board both have benefited from a detailed analysis of environmental justice impacts in the current proceeding?
I believe we provided a detailed response in CLF GRG2 regarding both the environmental and energy benefits of this project.
Thank you. Is it fair to say that during the construction for the proposed substation that surrounding areas will experience noise and airborne dust?
David, can you talk about, sorry, a little bit of our noise mitigation and what we do to limit dust and exposure to that to residents in the area?
Yes, so there's a number of regulatory requirements that were complied with during construction for noise mitigation and all types of environmental controls, regardless of its source, be it a sound source, be it a stormwater source during a rain event during construction, be it a promulgation of dust and erosion controls measures. All types of environmental protocols are always employed during construction.
I'll add to Mr. Petersile's answer as well to say that we also will have on the ground, so to speak, a field outreach team so that residents know how to get in touch with Eversource if they're experiencing issues with noise, dust, or other construction related concerns. And they will not get an answering machine. They will talk to a person. They will have our cell phone numbers, and we will be in constant communication with the direct neighbors so they understand what is happening, when it's happening, and what they can expect.
Go ahead, Chris.
Just to further add to what Meredith has said and David have said, the stormwater pollution prevention plan for the project that is part of the EPA's National Pollution Discharge Elimination System construction general permit requires that fugitive dust be considered, and not only considered, but prevented from escaping your site. And how we do that is obviously during hot, dry times of year, or when any specific activity is being done that would potentially generate fugitive dust. We are required to manage that. That's typically done through water trucks coming in and spraying the site, or any other site-specific activity or activity-specific activity to keep dust to a minimum, such as if there was any type of saw cutting or something to that effect that would need to be done. Water is sprayed onto the actual location to prevent dust from basically getting airborne.
And I'll just add, in addition to what Meredith had stated in terms of overall outreach regarding the construction, if granted this petition and application, we will continue to work with the City of Boston regarding the timing of when our construction hours will be, and make sure that the community itself is well aware of those hours and listen to any feedback that they may provide.
With updates on our website as well. We have a webpage dedicated to this project. And in the past, on this Mystic East Eagle Chelsea project, we had them, I think it was either weekly or bi-weekly email that went out to anyone who's interested in receiving those schedule updates with a 3-week look ahead.
And additionally, in regards to sound, the City of Boston noise ordinance dictates sound admittances and work hour restrictions relevant to construction within the City of Boston.
Thank you. Ms. Barica mentioned that the company will be in regular or constant touch. I'm not sure the exact phrase that she used with surrounding neighbors. How will that communication happen and in what languages?
So we strive to have many mediums of touch points or outreach, if you will. Currently, we are translating material into Spanish, Portuguese, Arabic, and we also can add Haitian Creole. We have done that in the past in this neighborhood as well. So we use multiple ways to get in touch with residents. We have done door-to-door door hangers. This in multifamily buildings, sometimes this can be challenging. We have done USPS mailers and have been sure to add a sort of a call out on the envelope so people don't mistake it for an electricity bill. We will do, as Ms. Bowden stated, we have a dedicated website already set up for this project where residents can get information in multiple languages. We will also offer, for those who opt in, to receive push notifications. Typically, we do these on a weekly basis to keep residents appraised of the next week's upcoming construction work. And we are open to looking for new ideas in some other parts of the city. We've put tables out and talk to residents just as they pass by or walk to give them project information. And we've considered doing the same in this neighborhood as well. So if there's the neighbors or the neighborhood associations have other suggestions, we would look forward and welcome to work with them on those.
Is it fair to say that operation of the proposed substation will reduce open space opportunities in East Boston?
So this is David. I think that question is very similar to one you proposed earlier today in relation to the remediation that was performed at the site and a potential for a limited use of the site for subsequent uses.
Yeah, this is Chris Newhall. I'll respond that the parcel where the substation is proposed is currently private property. It is not public property, and therefore it's not available for uses, open space or recreation. I'll further add that there's city-owned property between the proposed substation site and Chelsea Creek, and that property, I believe, is part of the Condor Street Urban Wild. So in terms of open space adjacent to water resources such as Chelsea Creek, the project would not reduce any recreation or open space lands available to residents of the city of Boston.
And to add on to Mr. Newhall's statement, I think I would offer that, in fact, this project is going to, in many ways, enhance open space and recreation opportunities in the Eagle Hill neighborhood. As already discussed, we will be providing significant funding for additional shade trees to be planted in the Eagle Hill neighborhood. Significant funding to upgrade the American Legion playground by installing shade benches, improving the bleachers that are there, as well as providing funding for green space initiatives and improvements, not only in the urban wild, but throughout the Eagle Hill neighborhood, benefits that we would not be able to provide without this substation.
I also think it's important to know, prior to us acquiring this parcel was not available to the community to come on and use. This was a private property then as well. So it's the same similar usage where it's private property, privately owned. It's not available for community use, and it never was available for community use.
Is it Eversource's understanding that East Boston has the lowest amount of open space per person compared to other Boston neighborhoods and nearby communities?
I am not aware of that specific statistic. The statistic that we have, or I have been made aware of, is the tree canopy, I know is the lowest in the city. I'm not sure exactly how the per capita open space susses out compared to the rest of the city.
There are numerous tanks for jet fuel, gasoline, and heating oil in East Boston. Is that correct?
Based on the information that we've been told in the past, yes, there are gas tanks in East Boston.
Is it fair to say that East Boston is home to an above average amount of industrial facilities compared to other neighborhoods in Massachusetts?
I don't believe I have the expertise to discuss other neighborhoods within the Commonwealth and how they relate to East Boston as it goes to environmental burdens.
Thank you. I anticipate we'll see some of those experts later on in the hearings. I want to turn to pages 21 to 23 of the petition for the certificate. And it discusses environmental protection and the previous siting board decisions from 2017 and 2021. With respect to environmental protection, in the application for this certificate, is Eversource relying on anything other than the siting board's findings in 2017 and 2021?
Ms. Rubin, could you repeat the page number from the application, please?
Yes.
That you're referring to?
21 to 23.
Thank you.
Well, while the witnesses are looking for that response, I wasn't clear whether you're asking if there are other agencies that have reviewed the project and either granted a permit or rejected a permit as it relates to environmental protection or environmental compliance with their standards. Is that essentially what you're asking?
No, I'm not. I'm really looking at what the company is relying on specific to the siting board's findings and those other decisions.
So again, just to be specific, bottom of page 21, item number 2.
Yes.
Okay. All right. Need a moment to refresh my memory.
Sure.
I apologize. Ms. Rubin, would you mind restating the question?
At pages 21 to 23, discussing environmental protection, Eversource refers to the Siting Board's 2017 and 2021 decisions and states that the Siting Board found that the project would achieve the appropriate balance among conflicting environmental concerns, as well as among environmental impacts, reliability, and cost. With respect to environmental protection, is Eversource relying on anything other than the Siting Board's findings in the 2017 and 2021 decisions?
This is Chris Newhall. I'm having trouble locating specifically that location, but I'll at least try to answer the question in that not only are we relying on the Siting Board's determinations, but we've also gone through the permitting processes through the Boston Conservation Commission and the Department of Environmental Protection for a superseding order of conditions under the Wetlands Protection Act. And again, also through DEP, through filing of our Chapter 91 license. And all of those requirements have been incorporated into the project design to avoid and minimize impacts to the environment. So in that regard, we are not only relying on the Energy Facility Siting Board, but we're also relying on other state agency and local permitting agency regulations for environmental protection.
Right. And additionally, to add to Mr. Newhall's response, I mean, the Siting Board is the lead agency for determining the particular siting of this energy-related facility. And it's the Siting Board who determined its adequacy in the prior proceedings based on all the factual evidence that was submitted by Eversource and in consideration of all comments from others that were proposed during prior proceedings in relation to environmental protection, public health, public safety, and public interest and necessity, which promulgated the Siting Board's prior decisions.
Yeah, well, and I would just add, I mean, it's Eversource's responsibility also to build a facility that doesn't detrimentally impact the neighborhood environmentally. And when you look at how we've built the substation with, you know, containment and fire protection and security and all those other things, you know, our project, our substation is not going to add to environmental issues in the community.
We can kind of ask John Zico to speak to some of the measures that have been incorporated into the actual design of the facility for containment around the transformers, should there be any release of mineral oil. Maybe you could briefly touch on what drives that from a regulatory perspective.
Certainly. And I'll refer back to EFSB, the reply to information request, EFSB G3, specifically part 1B. And it says, you know, in the event of a fluid loss in the transformer, i.e. a leak, the fluid will be caught in a full capacity containment pit under each transformer. The pit also has capacity for a minimum of 1/2 hour of fire suppression operation. And that is in accordance with an IEEE guideline, specifically IEEE 980, and it's for oil containment in substations. It's not from the IEEE perspective, it's not a requirement, but it is something that we did do here because of the proximity to the Chelsea Creek.
Hey, John, and I maybe you can just expand on that because of, you know, you have all kinds of sophisticated monitoring and controls back at SCADA. So, the chances of that transformer ever filling that pit full of mineral oil is probably negligible.
Right. And, to Mr. Hallstrom's point, the fluid level is alarmed in the transformer, and it's monitored 24 hours a day, 365 days a year, so that any fluid loss can be addressed as soon as it's detected. And the other point is that the design capacity of that containment is for the entire transformer. So it would have to literally, a drain valve would have to break off at the bottom. The alarm would have to not come in. And the point is you'd get an early warning long before that filled the capacity, and it would be an extreme event that would need to be required to fill that containment to its capacity, its design capacity.
Thank you. And maybe, Mr. Zico, you could continue by answering this next question. Are you aware of the proximity between the substation and the new police station gas tanks?
Yes, I am.
And what is the distance between those two?
That was also addressed in an information request. And if you bear with me for a moment, I will attempt to find it.
Yes.
Thank you.
John, that's EFSB G9.
EFSB G9, thank you. I am scrolling to that. I apologize for the amount of time this is taking. My computer is bogged down this morning, but I am looking for it.
John, if you could, when you get that, adjust your can't. There you go. You were off screen. Thank you.
Just one of the challenges I'm having today. And I have arrived at said information request. So I am looking at the reply to information request EFSB G9, and specifically the response, specifically part D, and it's the fuel pump is approximately 70 feet from the substation equipment.
Is it correct that number of 70 feet is between the building of the police station and the substation and not the gas tanks?
The gas tanks are below grade, and take up considerably more space than the pump island. What I did in replying to this IR was I took there was an aerial photo, and I scaled off of that as best I could where the fuel pumps were in proximity to the fence and the station equipment. So it's 60 feet from the fuel pump to the fence line and approximately 70 feet from the fuel pump to the nearest piece of station equipment.
Thank you. Can you estimate the probability of a safety issue relating to a release of mineral oil and proximity to those tanks?
The release of mineral oil itself will pose no safety issue with respect to the fuel tanks, either the jet fuel tanks that are distant from the station or the fuel pump at the police station.
Thank you. Let's turn to the company's response to CLF-GR-G-22. At the end of the second paragraph, Eversource states that the substation site is not the last remaining strip of land that could be used for community purposes. Is it Eversource's position that consideration of alternative uses of a site for community purposes is only relevant in situations where a site is the last remaining one that could be used for community purposes?
Please. Can you repeat the question, please?
Yes.
And please repeat the reference document.
Yes. I'm referencing the company's response to CLF-GR-G-22. And if it's helpful, it's PDF page 58 of 373.
And can you repeat the question again?
I can. I'm looking at the company's response in the second paragraph, starting with the word notably. My question is it Eversource's position that consideration of alternative uses of a site for community purposes is only relevant in situations where a site is the last remaining site that could be used for community purposes?
While the witnesses are pondering the question, relevance is a legal term in and of itself. And so I think you need to rephrase the question, not in terms of a legal concept, but perhaps why that was mentioned in the response. Otherwise, you need to define what relevance is and relevant to what.
I'm not asking about relevance in the legal sense. We can use the term appropriate instead. I'm trying to understand why the company responded in the way that it did in this paragraph.
Thank you.
So I'm going to refer back to the opening paragraph of that response. As previously stated, through these proceedings, reiterate that this is a privately owned property and therefore is not available for use as community green space or other recreative uses. That is the answer to that question.
Thank you. I will just note, Mr. Newhall, that you are a little bit hard to hear. If you can just try to get closer to the microphone, that would help.
I will try.
Sticking with this response, but moving on to page 2 of the response, which is PDF page 59 of 373. In the last paragraph on page 2, the company indicates that if it were to discontinue use of the site as a substation, additional efforts would likely need to be undertaken to further remediate the site. Isn't the company saying that the site would never be usable as a green space or recreational space?
The company's response there is referring to the fact that the current level of contamination on that site would not allow that site to be used for open space or recreation space or any other type of public uses unless further remedial activities were to occur on that site. And this refers back to the activity and use limitation that would be on that property as a result of our permit filings with DEP under the Massachusetts contingency plan.
Has Massachusetts Department of Environmental Protection issued an activity and use limitation for this particular site?
I will need to get back to you on that specific question. I don't know if they have issued that at this time or if that's finalization of documentation that would need to occur to again move forward with the construction of the actual substation. I know that a temporary solution has been obtained on the site, and I would need to double check if an AUL has actually been imposed on the site as of this time.
This is David. It has not yet. Our LSP is working on preparing the final documentation for the RTN closures.
And Mr. Petersile, when you say LSP, are you referring to a licensed site professional?
Correct.
Thank you. I'm going to turn to my last set of questions for this panel on siting alternatives. Assume for the moment that the substation is approved as currently proposed by the company. Can the panel describe how, if at all, this substation will change how Logan Airport receives electrical service from Eversource?
Thank you for this question, Stacy. It's fully loaded, so I want to give all the panelists a minute to think about it and refer back to any responses that we may have. As we do that, I'm then going to head over to Craig, who looks excited to talk about this, and we'll bounce it from Craig to the next person.
So this is David, and I can answer strictly as it relates to the physical infrastructure of how electrons flow to Massport. Currently, Massport, as the rest of East Boston, is solely serviced by Station 48 in Chelsea. And those distribution feeders come underneath the Chelsea Creek crossing, and then various distribution feeders service all customers in East Boston, of which Massport is one customer. This new substation, East Eagle, which will provide a new transmission supply to East Boston, because East Boston has no transmission services and therefore is an island relevant to distribution utilization voltage services. Once a transmission service is brought to the new substation, then it gets stepped down and distribution power, electrons, are flowed to all customers, including Massport, in the similar fashion.
If I could just add nothing to the response, but the essence of this question is actually tied to the need panel. It gets to sort of the technical nature in which electric service is provided in East Boston, including to Massport, and how facilities are operated within that area. So I don't know that we have our full need panel with us at this time, but Stacy, I might suggest that if you have further information you desire, that the need panel would be in a better position to provide a complete response.
Thank you, Attorney Rosenzweig. I plan to ask this and another detailed series of questions when the additional panelists are added this afternoon or a subsequent day. Mr. Hallstrom, did you have anything you wanted to add based on what Ms. Bowden suggested?
Well, just that, Logan Airport is a customer located in East Boston. And, with the addition of the new currently fed out of station 488 under the Chelsea Creek. And with the addition of that substation, the whole region will be, the two communities, Chelsea and East Boston, will be reconfigured to take advantage of the new station, the new, not so much capacity, but all the reliability and kind of redundancy, so the resiliency that the new station offers. So East Boston, Logan Airport, all the customers in East Boston will benefit from that.
Thank you. Let's turn to the company's response to CLF-GR-G-34. And here the company is stating that no, it is not possible that the potential alternative locations for the substation could have changed since 2014. It also states that the company must own or have rights to the land upon which substations are constructed. So just to be clear, is Eversource saying that in the 8 years since 2014, it is impossible that another piece of land could be purchased by the company or acquired to become available for the substation?
No, what I think we're stating here, Ms. Rubin, is that there's no alternative viable site that has come up in the 8 years that Eversource currently owns.
And Ms. Engstrom or others, can you articulate what would make a site viable?
So Eversource, as a utility company, looks for sites that are existing transmission facilities are nearby, such that that transmission facility can be tapped and looped in and back out of a new proposed substation, such as East Eagle. As we mentioned, the Chelsea Creek crossing provides that opportunity to loop in transmission service and then provide the necessary distribution services to the customers. That's first and foremost is the ability to be near transmission services. Secondly, site size is a factor for equipment layout purposes. A site's proximity to public ways as a means to build new underground duct banks and provide new distribution infrastructure to its customers. And those public ways, if they're already highly congested with existing utility infrastructure, would be a detriment, for example, to a particular site. And lastly, it is important to understand that Eversource has a real estate department that does canvass the entire geographical area that Eversource's Eversource serves for future load growth and development needs, and tries its best to identify sites for future development. And in my personal involvement with that real estate group, it's becoming increasingly difficult to find suitable sites for those facilities, especially in the current real estate market.
I would also say, David, that we're in these proceedings because we need to acquire the necessary permits to get the substation built at the current site. And so, you know, the idea of looking at alternative sites and moving towards that, it's not feasible due to the capacity issues that we're facing in East Boston. We need to get this substation constructed, and that's why we're in this permitting and override proceeding to get the necessary permits to get construction going, not to you know, relitigate or look at alternative sites here in this proceeding. This proceeding is to obtain the necessary permits to get the substation constructed and in service as quickly as possible, because there is a severe need there.
I'll just add on to that I think there's probably three components that we try to balance, which is ensuring reliable electrical service, environmental impacts, and overall costs.
Thank you. Given that the company sees no viable alternative locations for the proposed substation, is it fair to say that Eversource has presenting the siting board with two options in this proceeding? One is to approve the proposed substation location now and all of the relevant permits that are under discussion here, or two, allow outages to begin in East Boston?
I'm going to object to the question. I was trying to let the record go a little bit, but there is very clear established precedent in siting board override cases that an override proceeding or certificate proceeding is not a forum to relitigate issues that have been fully and fairly adjudicated. And the SJC has affirmed that standard on several occasions. And so while I was trying to let the witnesses speak and you ask your questions, in terms of essentially saying, is there another site, is exactly the question that cannot be relitigated and should not be relitigated in this proceeding, because it has been subject to 8 years and 2 separate siting board orders, the last of which was just a year ago. So from our perspective, that is an issue that is not subject to review in this proceeding. And while the witnesses have answered the question, further inquiry we would oppose.
It is our position that while there was an approval through the project change filing in February of 2021, that there is new significant case law that changes how the current statutory framework needs to be applied under the certificate proceeding.
Perhaps you can elaborate on that particular position, Ms. Rubin.
Absolutely. The roadmap law, as I've been referring to it today, does change the requirement for all agencies within the Environmental and Energy Affairs Secretariat and requires all decisions to consider environmental justice principles, which include the balancing and distribution of environmental burdens and benefits. Therefore, the siting question is very relevant to this proceeding.
And the company has responded to those questions both in discovery and today, but that question relates to this particular site. It doesn't relate to whether there are hypothetically other sites that have certain, presumably you think may have availed themselves in the last 14 or 15 months since the siting board's decision. The question on the roadmap law, which was as of April of last year, we have answered fully here, but the question is whether this site complies with the siting board standards in the roadmap law, not whether there are other sites that would be available that would conceivably be able to make this facility feasible.
And while I will respectfully disagree with that, the question that I did just pose that has led to your objection, Attorney Rosenzweig, is about the two options presented to the siting board in this current proceeding relating to the current site.
So if I'm clear, Ms. Rubin, what you're saying is not so much whether the company is obligated or the siting board is obligated to review alternative sites. It's what you're saying is that this particular site, the degree to which this particular site has satisfied, among other things, for example, EJ considerations, or whether, and if it does not, then the company cannot build at that site and therefore is in a position to need to regroup as a solution of providing service to the East Boston residents. Is that what you're trying to say?
That is correct. Thank you, presiding officer.
And as I indicated, we didn't object and we did respond to questions about our EJ compliance with respect to this project and this site. Same thing with the roadmap law. I don't know that there's more to be asked in those areas. I think her question is actually whether there is an alternative site that would be feasible and available. And I think that's not the proper question for this proceeding at this time.
With regard to whether we are going to consider alternative sites in this proceeding, then you are correct, Mr. Rosenzweig. We are following our consistent policy in reviewing certificate cases, which is an examination of the site before us.
Thank you. And again, my question was not about alternative sites, but was about the option for the siting board right now to approve the proposed substation location now or allow outages to begin in East Boston.
Well, I think, Ms. Rubin, perhaps you could rephrase your question if it's directed, for example, at the risks the company sees of future outages in providing service to the East Boston area in the absence of the construction of this substation. If that's your question.
In fact, I'm gonna move on, if that's okay, without getting an answer from the panel, and just ask one final question to this panel. And I'll save the other questions for the need panel, which I assume will invite some other people with some expertise. Is it fair to say that the residents in East Boston have little to no control over the large amount of industrial activity in East Boston?
I think we've all indicated that we're not residents in East Boston, so we don't know what controls they have on new development, existing development, construction, and that sort of thing in the area. I don't know what other developers are doing for community engagement and outreach. We can only speak to Eversource's community engagement and outreach. Eversource feels that we have worked with the community in a way that's collaborative, as well as in a way that promotes participation from community members with language access. And I think that's the extent of what we can say from a resident's point of view to address your question.
And to add on to Ms. Bowden's statement, in the work that we've done with the residents specifically regarding the aesthetic design of the facade, I think it's, in my opinion, a fair assessment to say that the community we've given are striving to give for them to guide the outcome of, the look of the enclosure, so long as it meets our safety and security standards, from everything from taking feedback over 3 different focus groups, making multiple revisions to the facade design with a brand new architectural firm that we hired after the original designs in 2019 and 2020 were rejected. So really working with them to ensure that their feedback was incorporated into the design and over the things that Eversource, the design group, has control over. We want to make sure the community is guiding those decisions and conversations.
Thank you. I know I said I had one more question, but your response led me to a few more questions. How many East Boston residents, unique individuals, attended the design series that you just referenced, Ms. Berica?
I can bring that up for you. I have a list. Bear with me one second.
Meredith, additionally, if you want to get the constant contact numbers, I know we had high turnout there
Yep.
for our constant contact as well.
Thank you, Nicole. So the first focus group, we had 5 residents in attendance. That was held in person in accordance with Boston's COVID safe mandates. And that was also held in person at the direction of the Eagle Hill Civic Association, felt that that would be the best format for the first focus group. The second focus group, we had 4 members in attendance. That was held virtually again at the recommendation of the community members who were in attendance at the first focus group. And then at the third focus group, also held virtually, we had 3 residents in attendance. As Ms. Bowden stated, part of our efforts in the focus group, part of the design process was to include not only elected and appointed officials, but members of Green Roots. And we did have extremely high, we know that most people saw the invitations and had access to all the materials that were presented at each of the focus groups.
Thank you, Ms. Berica. And you mentioned 5 people at the first session, 4 people in the second one, and 3 in the third. Were any of those people repeats between
Yes.
the 3?
Yep. Let's see here. I believe the 3 in the final were involved in all 3 focus groups. And then we had a little bit of melt, as you can tell, in the subsequent 2 from the first one. But there were 3 members of the focus group who were consistent throughout and are Eagle Hill residents.
Is it fair to say less than 10 unique people participated in those design conversations?
I can get you that. Who were not Eversource employees. So we did have some participation from some of the elected officials or their designees. Yes, we had about 7 members participate in the first focus group.
Elected officials as well as City of Boston, because we did have a representative from Mariama White Hammond's group, as well as the Commissioner of Parks and Rec attend.
And a representative from Representative Modero's office as well.
Thank you. And are you aware of the ballot initiative that was submitted as part of the November 2021 ballot regarding the substation?
Yes.
Yes.
And what % of City of Boston residents voted in favor of the substation?
I believe it was upwards of 16 point something, between 16 and 17%, I believe. I don't have the exact tally in front of me.
Thank you very much. I don't have any further questions at this time.
Thank you, Ms. Rubin. Mr. O'Brien, I just remind you that unlike some of the other interveners, the scope of your intervention under Section 10A is more limited and narrow than the rest of the interveners. So if you can keep that in mind as you're asking your questions, I'd appreciate it.
Certainly. Yes, thank you. Good afternoon, everyone. We have 3 categories of questions. They pretty well track what was asked earlier by CLF Stacy. The first category is just a couple on the Chapter 91. We have a few more on the benefit and burdens question. And then if it's agreeable, would like to jump back to the City of Boston permitting section that was taken up kind of on the first go round. We do have a few just preliminary comments. Yes, we know we're restricted to the environmental damage issue. Secondly, we don't have to agree with Eversource to really appreciate the high quality of the work that's presented. We definitely acknowledge that, as well as by the staff, EFSB staff as well. And finally, I think residents would like to go on the record as saying we use electricity, we like electricity, we need electricity. We also appreciate the proceedings, the rule of law, and the opportunity to assess these questions. So with that said, pardon me, just looking at the Chapter 91, and this is going to be in reference to the original EFSB approval and then the second. So it's 1404 and then 1404A. And it's focusing on the role of the city's BPDA within the Chapter 91 review. Pardon me. And so the Section 18 of Chapter 91 gives the planning board of the city the opportunity to review, and Section 5313, which is the City of Boston zoning code for East Boston, gives some standards. And I'm just first initially confirming that the company is aware of that and that this is something that you guys are all conversant in.
Let me start that you're referring to statutes and perhaps some regulations that are legal in nature. Now, maybe there are some witnesses that are familiar with some of that, but I don't know how far they'll be able to go. So I think you need to ask your questions, and then I'll be in a better position to gauge whether our witnesses are being appropriately asked a question. So
Sure.
proceed.
Sure. Yeah, fair enough. So it was stated that the site is within the designated port area. And is the company aware whether or not a substation is allowed use within the City of Boston zoning in a designated port area?
Again, I think you may have mixed a couple of things there, because DEP has regulations that deal with designated port areas. And then there's the City of Boston zoning, from which the company has received a zoning exemption from the siting board. And I don't want what the siting board has done and what the company has requested from the siting board to be confused with what's a part of the DEP's Chapter 91 regulations. So maybe try to get at it another way and ask the questions. Is a witness or witnesses aware of what a designated port area is and what its relation is to Chapter 91? That might be an appropriate question.
Sure. Is the company aware that under Chapter 91, the City of Boston Planning Authority has the opportunity to comment on a proposed license application?
Yes.
Yes.
Go ahead.
This is Chris Newhall.
We are aware that a Chapter 91 license application does need to get submitted to the local planning board for review. And they have to acknowledge that they've received that application as part of the Chapter 91 permitting process.
Sure.
And may I further add that the form that they sign is acknowledging that the site is the site or the use is consistent with the zoning and planning within the community.
Is the company aware that the planning authority didn't comment within the required time frame on the initial application, on the Chapter 91 application?
Restate that question. I lost track of it.
Sure. Is the company aware that the BPDA or then the BRA didn't comment on the Chapter 91 application as the city's planning board?
At what time
Are you specifically referring? The Chapter 91 license was originally submitted in 2014, I believe, and there's been subsequent public notices in that time frame in 2018 and then again in 2020.
Yeah, I think it was the 2020 application. It was the final application.
Correct. So in that time frame, Eversource specifically tried to get acknowledgement by the BPDA that they had received the application for a Chapter 91 license, specifically for the new location off Condor Street. And the BPDA never responded to any of our inquiries, which were numerous, both via email and telephone. At one point, we did get an email response from BPDA in relation to our request for them to respond that they had, in fact, received and reviewed the application. But that was as far as we got from the BPDA for an acknowledgement that they'd received the application and reviewed it.
Yeah, thank you. That's very useful. To the degree to which we could make an information request, and it's not, if it's not already in the record, would like to see the documentation of those inquiries by the company to the BPDA and the response, the apparently very short response that was given.
Okay, I will give you what we can. Some of it may have been oral, but if there's anything in writing, I think Mr. Newhall's answer was complete. But if you want confirmation of that in a record request response, we don't have an objection.
Yeah, thank you. Just a few more on this.
So that would be record request BRG-1.
Yeah, so thank you. There's just a few more on this Chapter 91. The company entered into an agreement with the city, a land conveyance agreement that, among other things, the city agreed to essentially waive all objection or not to raise objection. Is it the company's position that this waiver applied as well to the BPDA?
Oh boy. Again, that's a legal question. You're asking for them to draw what is in essence a legal interpretation about the legal requirements of an agreement that was entered into. That would not be a proper question. You may ask them if they're aware of a particular provision, but the legal import and requirements that are associated with that, I think is beyond what these witnesses are presented to testify on.
Yeah, fair enough. And just two more on this, and maybe I can, hopefully I'll ask this the right way. Is the company aware that a substation is a forbidden use in the waterfront manufacturing district where the substation is proposed?
Again, let me just try to correct your terminology. You said forbidden use. Do you mean, is it a permitted or authorized use under the local zoning code as opposed to forbidden? Are you asking whether it's a permitted use?
I'm asking, is the company aware of what the use designation is for a substation in the waterfront manufacturing district?
Again, Mr. O'Brien, can you repeat your question?
Yeah, and I apologize if I'm not framing this precisely, but is the company aware of what the zoning, whether a substation is an allowed use within the waterfront manufacturing district of this site?
This is John Zico. I was involved in the underlying case when the original zoning exemption was sought, and one of the reasons that the original zoning exemption was sought was because a substation was not an allowed use in the zoning district where the property is located.
Great, yeah, thank you. And last on this topic, is the company aware that open space is an allowed use at this site?
I am not, for purposes of what we were doing, I focused on the station. There may be others on the panel who can speak to that.
So in relation to zoning bylaws in general, zoning bylaws typically have tables of use regulations, and they provide for what's considered permitted uses by right. Beyond that, landowners or proponents who have a particular use typically would either have to apply for an exemption through the Zoning Board of Appeals or a special permit through a Zoning Board of Appeals for a particular use. So I believe in this case, a substation is probably, and in many municipalities, I'm speaking from personal experience as I was a member of a town of Stoughton Planning Board and also involved with many zoning issues. Typically, a substation or infrastructure type facility isn't even listed as a permitted use on any codified zoning bylaw, okay, because it's a special circumstance. And in that regard, that's most likely why Eversource had to go get the zoning exemption for the particular use. And I correct me if I'm wrong, others, but I think that's the proper response.
One thing that I'd just like to note, Mr. O'Brien, you framed this relative to Chapter 91. Your questions and comments have really been zoning. Relative to Chapter 91, the department, Mass DEP, and the regulations identify a power substation as an ancillary facility to an infrastructure crossing facility. Infrastructure crossing facilities are water-dependent uses, and therefore water-dependent uses are the preferred use in filled tidelands and an allowed use. Further, it being a filled tidelands within the DPA designated port areas are so identified to promote the use of those lands for industrial uses. So in terms of Chapter 91, yes, it's perfectly suitable site.
Well, the BPDA didn't comment to that effect. It didn't comment at all, apparently. So moving on to the next topic, if I may, the point about not introducing and relitigating, we totally get that. But at the same time, if there's new information that's relevant, presumably we're free to introduce that. So what I'll be talking about now is stuff that happened, items, information, events after the February 2021 second approval. First of all, could the company describe what the status of the February 2021 approval is at the moment? EFSB approval?
Well, that's a legal matter, and I can stipulate for the record it's under appeal at the SJC.
Right. So it's under appeal right now. And related to that, is the company aware of Attorney General Healy's statement on February 22nd that East Boston already, I'm reading, quote, East Boston already bears a disproportionate burden of industrial infrastructure and the associated environmental and health risks, and today's decision will only increase that?
Is your question whether that was something that Attorney General Healy said?
My question is the company aware that she said it?
Mr. O'Brien, I believe that within some of the testimony that you've sponsored, there were statements to that effect. Is that correct?
Yes. Mm-hmm. Yes, it was in Ms. O'Brien's pre-filed testimony as an exhibit.
So I'm not clear because as we had the prior discussion, the question of whether this site is an appropriate site under the siting board standard has been fairly and fully adjudicated. Now, whether Attorney General Healy agrees with that or not, I'm not going to speak to, but that issue certainly has been fully and fairly adjudicated by the siting board, and as such is not a proper topic for review in this proceeding.
I guess what I would say is, to the extent that Mr. O'Brien is trying to make the point that the Attorney General has expressed her opposition, he's certainly made the company aware of that by virtue of the testimony he provided in this proceeding.
Yes, and we do appreciate that it is relevant, and it's subsequent to the decision. And I will also point out, but I will get to a couple of questions very quickly, that the company has made much of the purported efforts to show support within the community in its outreach efforts. So it's equally available to us to show that that's not universal. And so moving on, just a few more questions on this topic. Can the company characterize the position of Mayor Wu, State Rep Senator Edwards, and Rep Modero on the substation?
Again, I would not want to characterize elected officials' positions. That would be up to them, who would be better suited. I would feel we would be stepping outside our bounds to express the position of Mayor Wu and elected officials such as Ms. Edwards and Representative Modero.
Yeah, fair enough. Fair enough. I think the record reflects that. The advisory ballot measure, over 100,000 people in Boston voted for the substation if needed at an alternate location. Over 80% of the people in East Boston voted to that effect also. Does the company have an interpretation of how much weight to give that advisory ballot measure?
We have no way of knowing how many residents of East Boston voted on that ballot. It was residents of all of the city of Boston that participated in that ballot.
Is the company aware that the city breaks down its voting totals by precinct and specifies East Boston precincts?
I think I'll go back to answer your first part of the question. We've certainly taken a look at that ballot. I think that the way that the question and ballot was worded certainly would get the response that it received. Had the question been worded to also talk about the benefits of the substation, or the fact that, these communities right now are underserved in terms of a reliability and energy perspective, I think that we could have seen a different response, but we have no way to speculate that.
Sure. And did the company make any effort to educate the voting population of Boston about the benefits?
We've done that significantly in the East Boston neighborhood, because the substation will provide service for East Boston and Chelsea. And we've done quite an extensive outreach to educate the public on the need for the substation, the benefits of the substation, and work through the collective bargaining agreement as mitigation for some of the potential seen burdens of the substation.
I'm sorry, the potential what burdens?
The potential seen by the neighborhood burdens of the substation.
So I would just also add, Mr. O'Brien, that while we were not involved in the actual writing of the ballot question, we certainly followed that process along, and folks that were involved in that process certainly have been educated by Eversource on the benefits and the overall substation project itself.
So can I just, when there's a good breaking point, Mr. O'Brien, and you're sort of transitioning, I think our witnesses are hungry, and perhaps it would be a good time to take a break. But I don't want to interrupt you if you're at the end of a particular line of examination.
No, I totally get it. Just a couple more on this, and then maybe city permitting we could take up after a break if we're willing, if that suits everyone. So would the company agree that the voters of Boston, East Boston particularly, made an informed choice on the advisory ballot measure when they voted overwhelmingly to reject it at the proposed location?
I think we're looking at a subset of the residents in the city of Boston. I don't think, based on what I've seen, there was a huge voter turnout. And again, as Ms. Engstrom stated, the question itself was worded in a way that drew on the emotions of the voters. I think that if, again, some of the benefits were put in that discussion, such as the CBA executed agreement of $1 million to better the community, the benefits to East Boston and Chelsea, because as you know, if we do lose power in East Boston, we also lose power in Chelsea. So the benefits of maintaining a reliable electrical system in both of those communities, as well as the overwhelming development that's happening in East Boston, from a commercial standpoint to residential, the need for additional electricity is there. Had that question been worded in a way that discussed the benefits as well, that would have probably given voters a better overview of the pluses and what folks may see as minuses, to make an informed decision in that ballot question.
Sure. Thank you. I just have a couple more questions. The company had the opportunity to help inform voters for sure. Just very briefly on the question of the remediation, right? The site remediation. The company did the remediation, and when the company decided to proceed with remediation, in the absence of all of the permits and approvals necessary, did the company do so under the knowledge that it was contingent on subsequent approvals?
We embarked upon
The remediation efforts at the substation site in an effort to prepare that site for its use as a substation site. And that was done, I believe, after we had fully purchased that site from the city of Boston, such that it was done with an understanding that it was private property and we were pursuing its use for the Station 131 facility.
But would the company acknowledge that it did so?
Can I add into that, please? Yep. So there's when an administrative consent order is attached to a property, the property owner is required to perform remedial efforts, regardless of what any future development may occur at that parcel. So Eversource, being a good steward of the environment, was obligated, once it took ownership of the property from the city of Boston, just as previously the city of Boston would have been obligated to perform remediation. Eversource performed the remediation as required by DEP administrative consent order.
Yeah, no, that's a good answer. That makes total sense. Thank you. Two more questions. As a public utility, the Eversource has the ability to enter into a public benefit taking or an eminent domain to locate a site if it's deemed necessary.
Objection. That's a legal question.
Okay. And the last question on this topic: should the certificate not be granted, or should the SJC have an adverse decision, or should any other party sort of continue this process so that a final decision cannot be reached? Does the company have in place a contingency plan to provide what it has characterized as urgently needed electrical service to East Boston.
Is that a question for the need panel, Mr. Rosenzweig?
I think it is. It's a Plan B type of need approach that I think the need panel would be better positioned to address.
Sure, we're happy to then end our questioning for this phase. Thank you for your patience.
Okay, I do have a few very brief questions for the permitting panel when we come back from lunch, but I shouldn't take long. So it's 1:15. Let's come back at 2:15.
Certainly, but just to be clear, we do have a few permitting questions as well.
That's fine, Mr. O'Brien. You can ask them after the break.
Great, thank you.
Okay, off the record.
And may I ask Ms. Bowden one question, please?
Alan, go ahead.
Alan.
You were answering a question a while back, and you said elected officials as well as City of Boston, because we did have a representative from our something Hammonds group, as well as the Commissioner of Parks and Rec attend.
Oh,
that would be Mariama White Hammond.
Great, thank you very much.
Ms. Sharkey, can you hear me okay?
I think she's on mute, but I can hear you, Erin.
Okay, thank you. I switched the laptops.
I was going to say the sound is definitely better, Erin. Thank you.
I am not able to start my video. Should I be? It says the host has stopped me.
Well, that would be Andy. Here, let me check.
Okay, I just got assigned it. I can start it. Okay, thanks.
Service. Please check the number and dial again. Or
Alan, I think in the transcript, somebody was talking about the DEP witness. And I think it said, you might have already corrected it. It said Hobson, and I believe it's
It's
Hobbs.
Hobbs. Yeah, I
Yeah.
already did correct it. Thank you.
Thank you.
It's Chrissy Hopps, Hopps. Thank you.
Oh, okay. Well, I corrected it incorrectly.
That has happened in other cases where they have thought it was two B's instead of two P's. So I just wanted to make sure that you had it.
I didn't, so thank you.
No problem.
So if the panel witnesses could just turn their video on so I know they're there. Okay, let's go back on the record. Before our lunch break, Mr. O'Brien was asking questions of the permitting panel.
I'm ready to proceed if that's where we're at.
Thank you, Mr. O'Brien. Go
Yes,
ahead.
yeah, thank you very much. So this will be a focused set of questions on the City of Boston permitting. And it really goes back to the session of a couple of weeks ago. And I think it was Mr. Petersile who was providing most of the information, but whoever all, of course, can answer would be great. And just to make sure we're on the same page, I'm just going to focus just on the City of Boston. So I know there's a Chelsea piece, but it's just the city. Can the company confirm what are the pending permits that are the subject of the certificate?
David, do you want to go ahead and go down the list?
Yes, I'm looking for hold on, give me a moment and I'll find the list, I'll find it for you. It's contained in two places. It's actually in the application, which,
Yep.
and then it's additionally It's one of the, hold on.
Mr. Petersall, maybe EFSB P12 would be a resource for you.
Yes, thank you. That's what I was looking for, the updated permit status list. Okay, so it's EFSB P12. And that's a table of the lists of a table of the current status of each permit that's being considered under this proceeding.
Great. And there's been no change since then of just the city, not Chapter 91 or Chelsea, and not also the order conditions. It's just the parks, PIC, water and sewer, and I think maybe one other one, Public Works, maybe.
So there's been no change to this current status of the permit applications since the last convening of this body.
Great, thanks. And this has the city denied any of those listed permits for those departments and commissions?
So again, the current status is identified and itemized.
Yep.
Line by line in that table, and there's
Yep.
been no change to the current status.
Okay, cool. So where residents are most familiar with the rec and parks and the PIC, to some degree, water and sewer. So we'll focus on those, but it also may apply to Public Works as well. So in the last Q&A session, for example, we talked about the checklist that Rec and Parks Commission provided. PIC also has a checklist. Does the company know if the checklist provided were different for this substation proposal than for anything else that any other applicant would be required to comply with?
The checklists are published on the City of Boston website under each department for the particular permit that department educates.
But you have no reason to believe that they're different for the substation as opposed to any other project?
No, I have no reason to believe that. It's any applicant for a particular PIC application. And in our case, it was grants location and specific improvement plan, or a City of Boston Parks and Rec Department.
Yeah.
Those checklists are published on the City of Boston website, and I would assume that they're common to all applicants.
Sure.
I wouldn't see why they wouldn't be.
Yeah. And so would the company agree that a city or town has the right within some reasonable level of rule of reason, let's say, to set their own requirements and publish them as checklists?
And that's a legal question, whether they have their authority or whether they're subject to a superseding authority of the citing board, which is in essence a question of law for this proceeding.
Sure, fair enough. In your experience in navigating through approval processes, which is not easy, which I think we can all acknowledge, it takes a lot of work and compliance. Oftentimes sort of things come in later, or they don't seem reasonable, or they're unexpected. But would the company agree that a city or town has the right to change its requirements based upon a change of mayor or city council or board of selectmen?
I think, David, you probably need to jump in here. That seems a bit legal as well.
Just about to. Same question. We're not here to answer legal questions about what the city may be authorized to do, at least as it relates to our witnesses' testimony.
Sure.
I think you need to sort of focus your questions on actions that the company has taken or factual or technical material that relates to the permits that are being sought.
Yeah, fair enough. I just have a very few more. So at the last session, I believe the company was asked
when they would start construction were the certificate to be granted. And I kind of was surprised you didn't say, well, that afternoon, but it was an interesting question because it goes to sort of where this proceeding fits in. Under the assumption, which is by no means certain, that the certificate would be granted, what other remaining permits, if any, would exist before construction might start?
To my recollection, I believe that same question was asked at the initial hearing date.
Yeah.
And I'd have to go back and research where in the record what the response was, but from memory, again, the list of permits that we're seeking the board to provide for us to be able to begin construction are itemized in the petition, and Eversource needs to begin construction on the substation post haste.
Sure. No, I think that's right. I wasn't sure either by my memory. But is it the company's position that the construction, let's just say that this proceeding goes forward, the certificate is approved, that construction cannot begin until the SJC proceeding is resolved?
Boy, would I love to answer that for you. Let me just say that is a legal question. I do think one of the answers to a discovery request identifies counsel as a respondent and provides some material in relation to that, but I really wouldn't want to go beyond that at this point.
Sure, but if you could direct me to the citation, I'll look it up. That's fine, but I think it does have relevance to Mr. Petersall's experience in the sense that it's not, is it, Mr. Petersall, your experience that in seeking to navigate through the permitting process, that agencies, cities and towns typically would not grant final, like a building permit, the final penultimate permit, where there is a pending legal proceeding of any kind?
You're on mute, Mr. Petersill.
In my personal experience, regardless if it's been with Eversource or others, I've not been in that situation, so I can't answer that from an
Mr. O'Brien?
experiential perspective.
I think the most important thing that I'm getting from your question, Sam, please correct me if I'm wrong, but Eversource intends to continue working with the city of Boston. Even if this certificate proceeding is granted and we receive the necessary permits, we will continue to work with the city of Boston as we approach construction and as we look to put this substation in service. So I think you're looking just to see whether or not we want to continue cooperating and working and collaboratively ensuring that the residents of East Boston have reliable electricity. And the answer is yes, we will continue to work with the city of Boston day in and day out. That is my responsibility as the community relations rep, and that is the responsibility of this project team to continue these open, transparent communications with the city of Boston.
Sure. This is my last question. I'm going to preface it a little bit in response to what was just stated. The preface is that we understand the public policy rationale of our certificate proceeding. There are situations where it makes total sense and it's in furtherance of reliable electricity. At the same time, there are occasions when it's either premature or there are other balancing considerations. And the company has confirmed that they've not received denials. The company has not indicated that there's a non-regulatory condition or inconsistencies, but the question seems to hinge on whether there's been undue delay. And what I'm understanding is that in cases where there's a pending litigation, it's standard practice to not further process a permit. And I would just ask the party, was it Nicole? Yes, Nicole. Hi, Bowden, Ms. Bowden, whether or not the company agrees that it is not unusual for the city of Boston to delay or hold processing a permit where there is pending litigation.
So
Just before the witnesses respond, and then I will let them respond. I think you've shortcut what our explanation was in our petition for the grounds on which the siting board has statutory authority to grant a certificate. It wasn't just undue delay. But if your question is repeating the last question you asked, is it customary in Mr. Petersile or Ms. Bowden's past and their experience for agencies, all agencies, to forego considering permit applications if there is any appeal pending? I have no objection to them answering that question if they have information relating to that.
No, Mr. Rosenzweig, I was just going to say our concern is to ensure, as I've been saying all morning and afternoon here, reliable electricity to these communities. And we're getting to a point where you may not believe we were unduly delayed by permitting, but we're in a position where we have to ensure that the reliable electricity for all of the residents in East Boston and Chelsea, because we can't forget that they are affected as well. It's in question at this point. And I'm not sure if Craig Hallstrom is back with us, but as summer temperatures begin to rise and we're seeing, more construction and new developments come online, we are at the point where we can no longer wait. We've worked with all these different permitting agencies to the best of our ability, and now we have to come to our regulators to try to receive this override permit to ensure that we continue to do the job that we have to do, and that's provide reliable electric power in these communities. And if we don't, that's not a good day. And I have Craig Hallstrom here to elaborate on that a little bit more.
Well, Nicole, I just echo your comments. I mean, the reason why we're here today is we're asking help to push this project through. We're at the brink of not being able to serve our customers. And then myself, as really probably the only person on the call here who's responsible ultimately to keep the lights on. It's critical, and that's why I'm here. It's critical to get this project move forward, and we've come to the siting board to ask their assistance to that.
Sure. The comment by Mr. Rosenvig leads me to one last. I promise that this is the last one. And I know that the Q&A is not an opportunity for advancing argument, but is it the company's position that a condition is burdensome if it's applied equally to any applicant?
David, do you want to chime in here first before we take a stab?
Yeah, we would need a lot more there. Under what conditions and what applicants are you talking about? I mean, are situations and facts relating to what the needs are for that project to be taken into account? I mean, we would need to know more about what you're asking about, because all of those factors, I'm sure, would weigh into the witnesses' answers.
Residents have no further questions if the company chooses not to answer, but very much appreciate everyone's thoughtful responses.
Thank you, Mr. O'Brien. Do any of the other interveners have additional questions to ask the permitting panel?
None from the department.
Thank you.
I'm sorry, who said that?
Mr. Bragg.
Mass DEP.
Oh, thank you.
In that case, Mr. Petersill, I wanted to ask you, in the last hearing we had May 17th, we had a discussion with regard to the building permit that the company was working on. And I believe if you look at page 35 of the transcript, the company said that they were working on additional information to submit relative to that permit, which they expected to provide by the end of the month. Do you know, has the company provided additional information with regard to the building permit?
Unfortunately, no, we have not yet. We're still assembling that information. Some of that information we can't necessarily provide because it's information they're asking relevant to other City of Boston agencies who obviously have not provided their inputs that we would need to give to this inspectional services department. So it's that proverbial catch-22.
If you could look at the response to record request EFSB 3. And like many of responses we received from the agencies as well as from the company, they were unable to provide approvals or denials for similar substation proposals. Can you tell me, does the company also need to, for example, go to Parks and Recs for some approval when there are projects that involve not a substation, but for example, installation of transmission or distribution lines in the vicinity of a park or a ball field that's under the auspices of Parks and Recs?
So
Or is,
go ahead. I'm sorry.
Or is it just limited to structures, above ground structures?
So while you were speaking, I was trying to find number 3. Was that general 3 or permitting 3 or?
No, it was your record request response, or the record request responses that came in, I believe, May 31st, maybe? Or that week.
Can we just have a moment to get Mr. Petersile that information if he doesn't have it accessible?
I don't have that accessible at the moment. There's a voluminous amount of information I'm trying to sift through.
I understand and sympathize, especially trying to retrieve it on an electronic basis.
Yes. But while someone sends it to me, the gist, I believe, of your question was what falls under the Boston Parks and Rec Department ordinance relevant to the 100-foot rule, I believe. Is that the question?
That's correct. And I was wondering if it was there was a difference drawn with regard to infrastructure you install that is either beneath the streets, for example, and therefore would not be characterized as a above ground structure.
I'll answer based on my experience, and maybe Chris Newhall could also answer based on his experience. My experience is that it does not differentiate between the nature of the project. It's strictly, does your project come within 100 feet of a park?
So, for example, the company has some other recent projects, such as the Andrews Dewar line and the Seaport transmission line, which would you have needed to receive some type of permit from Parks and Recs for being within 100 feet of a public park for those, for example?
So that's a very good question. So I happen to be the project manager on the Andrew Square to Dewar Street transmission line project, and others on the panel are also familiar with this. For that particular project, the transmission line, which the portion of it that is under a paper street that's adjacent to a ball field, that's a Boston Parks and Rec Department, area of authorization. We did not have to go through the 100-foot rule application process. What we did do is we did coordinate with Parks and Rec, and they advised us that it was not necessary to go through the 100-foot rule because it was underground duck bank infrastructure. There was really no building component, so to speak, that would have any impact to the park. It's basically it's a non-visible element that would be below grade. But regardless, the coordination and communication occurred. And I believe there was a permit sought for like land use rights, for example, the rights to put the underground facility in that parcel, like an easement.
But I'm just trying to ascertain if there were, even if there weren't, for example, comparable substation proposals, if there were other Eversource Energy projects that did need to go to Parks and Recs and receive some kind of
Yes, the
authorization.
Andrew Squidador is a perfect example. Yes, we're currently working with Parks and Rec on several different permits and easement usage for that project.
But however, and I can tell you exactly what those elements are. However, they're not under the 100-foot rule requirement. There's really land use rights and construction access permits.
And has the company experienced delay in working with Boston Parks and Recs on the approvals it needs to receive for example, the Andrew Dewar project?
I can characterize that by saying it's taking quite some time. So it's been very lengthy. We have not received a fully executed license agreement for that element of the land use rights yet.
And speaking with Parks and Rec last week, they fully acknowledged that they owe us updates and materials, and they're working towards getting that to us. But it has taken, like Mr. Petersall said, a bit of time and longer than the company is used to or would like to see from a turnaround.
Just add that as a result of that delay, that has also held up our PIC delay as well, of getting on the PIC agenda for that project.
Okay, thank you. If no one has any further questions, or if the company has, does the company have any redirect they'd like to do at this time?
I believe the answer is no, but could we have a short moment off the record just to confirm based on the last series of questions that were asked?
Sure, you'd also, of course, have the opportunity to do it on the cleanup day.
Then let's let it roll. Let's not hold things up, and there'll be a break at some point this afternoon where I can confer with the witnesses. So continue on. Thank you.
Ms. Sharkey, I actually had a couple.
Oh, I'm sorry, Mr. Wang.
Sorry, my microphone wasn't pulled down. Could I refer the company really quickly to your response to our information request EFSB-P-11? I'll give you some time to get there, but it has a list of all the permits and their purposes for which the company has requested under the certificate. Okay. Could the panel, whoever is able to answer this, please state briefly if any of these permits address aspects of public safety?
Well, that's kind of a general question. I mean, public safety is a topic, if you will, that many agency permit applications require an applicant to address. So it's to pick and choose which particular ones specifically or solely address safety. I don't know that we could properly do that. I'm sorry to respond in such a quizzical way, but
Thank you. That's clear. And my next question was similar, and the answer might be the same, which is, do any of these permits specifically address public health with regard to the project?
it'd be a similar answer, honestly. It's
Thank you. Finally, so I think Ms. Sharkey had asked about the building permit, which from what I understand from the company's response to EFSB-P-7 was that the company is asking for the foundation permit, and then the building permit would come after the facade review is finished. As part of a record request, could we ask for an example of a issued building permit for the record?
yes, and one was provided in EFS. It's attachment 8 to P11 was a sample City of Boston Inspectional Services Department building permit.
Thank you, Mr. Peterson. Okay, that's all I have for now. Ms. Sharkey?
Thank you, Mr. Wong. If there is nothing else, I guess I need to also double check with the company with regard to whether there's an intention to, at this time, to withdraw any of the pending 15 permits that the company has requested.
In that this is sort of a legal issue, let me just comment. There are 2 permits or approvals that fall into that category, we hope, but the timeline has not completely played out with respect to those permits. They both are related to the company's notice of intent, Conservation Commission approval, DEP's permitting of that process, as well as the challenge to the Conservation Commission's approval under the local ordinance. It's my expectation within a matter of weeks, we hopefully will be at that point in time to file something officially that indicates final non-appealable approvals are in hand. Approvals are in hand, but they are still subject to some trail period for potential contingencies about their finality. One of them are waiting for a final DEP order confirming the dismissal of the appeal of the SOC. And on the other, we're looking for final docketing by the appeals court of the ordinance challenge, which has been dismissed, but just needs as a finality and formal matter to be docketed by the court, and that has not occurred yet. So the answer is we're hopeful there will be 2, or at least 2, and we're hopeful to be able to be in a position to provide that information for the record in short order, but not necessarily tomorrow or the next day. We're not in control of the timeline.
So, for example, the appeal periods have expired, but you don't necessarily have the final administrative action to demonstrate that the determination was final.
That's on the DEP side. That's correct. There was a withdrawal of the appeal by Ms. Miller at the DEP level, and so a request for a final order of conditions or confirming this SOC or otherwise a FOC, a final order of conditions, be issued by DEP. And that has to come out from the hearing officer at OADR and then be adopted by the commissioner of DEP. That has not occurred yet. We would expect that to be the case because the appeal has been withdrawn, but as a formal matter, I don't want to get into what hypothetically could happen, but we have not received finality on that. And I can get into the other one if you wish as well, but.
Well, I was going to say, with regard to the Superior Court action, are you waiting for some action by the court to essentially demonstrate that the appeal has been dismissed?
That is correct. It has been dismissed by the appeals court on one or two rulings in the past 30 to 60 days. But there's a process called rescript that the courts go through when an appeal is finalized, and that enters the appeal or the dismissal of the appeal as a formal matter on their docket and reports it to any lower court that was involved. And it's sort of those nuances and niceties that we're trying to make sure are perfected before we formally withdraw that permit request from the certificate that we have sought at the outset.
Thank you, Mr. Rosenzweig. I appreciate the explanation. Mr. O'Brien, your hand is up.
Yes, very briefly, would it be timely just to update on the City of Chelsea status? We residents would find it helpful.
Mr. Petersall, do you have anything to add to the discussion with regard to the City of Chelsea information that was provided in the last evidentiary hearing?
In regards to the single permit application, is that the question?
I believe that's what Mr. O'Brien is asking about, but maybe he can clarify.
Yeah, if we're talking about sort of what's been resolved or what remains pending, has the Chelsea review and approvals been resolved, or is that still pending?
That is one of the permits that are on the table of permits, and nothing has changed.
Thank you.
Does anybody else have a question? In that case, let's move on to the resumption of need. And if you want to take a couple minutes for everybody to get on, we appreciate everyone who's already provided testimony today.
Mr. Freeman, are you available? Thank you. Thank you. There, I see you. I believe all our need-related witnesses are present and accounted for.
And does anyone else need to be sworn?
I think the answer is no.
Okay. Then I'd like to remind the witnesses on the panel that they were previously sworn, and we will resume with intervener questions, I believe, of the need witnesses. Ms. Rubin, I know CLF was asking questions towards the end of the day on May 17th, so the floor is yours.
Thank you very much, Presiding Officer Sharkey. Good afternoon, panelists. I'd like to turn your attention to the company's response to EFSB-N-11. So Part A of this response appears to be the company describing step loads that were not previously described to the siting board. Is that correct?
Me well, this is Juan Martinez.
Thank you, Mr. Martinez.
I'm sorry, I didn't hear the answer.
Did you
That
say
is-
something before you said this is Juan Martinez?
Yeah, so if you refer to EFSB N11, Part A, the question is, are these step loads that were not previously described to the siting board? And the response is there. So yes, these step loads were not previously described to the siting board.
Thank you. I'd like to look at the table on page 2 of that response, the colorful table. The bottom row of that table in red indicates a step load of 4.8 megawatts of 2022 estimated load additions from Hertz Auto Rental, correct?
That is correct.
And does this load represent an increased load from the electrification of Hertz's rental fleet at Logan Airport?
This is from electrification of Hertz rental fee. That's correct. I believe it's the location of parking lot that's adjacent to Logan. I don't know the exact location where the chargers will be placed, but it's part of Hertz rental.
Thank you. And is that for future electrification or for existing electrification or charging stations that are already operational at this moment?
This is new. So this step load was very recent, as noted. This is basically a new step load. It's pending. It hasn't been connected in service yet, but it's information we receive on step load that is coming. It's new information we received that was added to the step load. They're not installed yet.
Thank you. And the top row in pink indicates a step load of 3.5 megawatts of 2022 estimated load additions from Massport. Is that correct?
That is correct.
And if we add up all of the 2022 estimated load additions for steps that are either certain or complete, that is all the rows except for the second row, you would get 14.8 megawatts. Is that correct?
Can you repeat that question,
Yes.
Ms. Rubin? Sorry.
So I'm having you do a little bit of hopefully easy math. If you add up the 2022 estimated load additions for steps that are either certain or complete, that is all the rows except for the second row, you would get 14.8 megawatts, correct?
Yep, do the math right now. Give me a second. Yeah, 14.8. And that's the addition of the 3.5 plus the 1 plus the 2 plus the 1.5 plus the 2 plus the 4.8 that are 2022 estimated load additions in table EFSB N11.
Thank you very much, Mr. Martinez. I don't think I'll have you do that much more math. The Hertz and Massport steps combine the 3.5 megawatts and 4.8 megawatts, which equals 8.3 megawatts, correct?
8.3, that's correct.
And would you agree that the 8.3 megawatts accounts for more than half of the 14.8 megawatts of estimated load additions for steps that are either certain or complete that we just discussed?
For what is given in table EFSB N11, that's correct.
Thank you. And is it fair to say that load growth like the ones at Hertz and Massport will continue as we see more electrification of rental vehicles in the future?
I think that's a good question, but load growth in general, I think, will continue in the area of East Boston and Chelsea. And we're actually, I could refer you to another question, which let me bring it up actually. So in EFSB N6, we try to expand on what we think are the need for the load growth in the area. And one of them is, I know there's a lot of focus on step loads because it's something that we can visually see, and those are numbers that the panel and anybody can point to. But also in AFSB N6, we pointed out that there's also known unknowns. And those are a lot of residential growth that is also happening in the community of East Boston. So to answer the question, yes, we expect load growth as shown as part of the step load, but also as shown as part of natural growth in the area of both East Boston and Chelsea. Specifically East Boston, we highlight that there has been a significant amount of growth, especially kind of in the residential arena, and that's highlighted in EFSB N6. So combine all of those, electrification, commercial, residential, yes, there is expected load growth in the area of East Boston and Chelsea.
Thank you. And given the load growth that I mentioned for Massport and Hertz, is it possible that locating the substation at Logan Airport would contribute to electric reliability?
I think also
I will object. It comes back to a discussion we had this morning about alternative sites and that being fairly and fully adjudicated in prior proceedings. And so we think that is not a proper scope of inquiry in this matter.
I will move on. I'd like to turn the panel's attention to the company's response to EFSB PA-4. In Part B of this response, the company reiterates its response to the previous request EFSB-PA-1 that active demand reduction programs could not fully achieve the necessary reductions. Is it fair to say that Eversource has not assessed whether active demand reduction programs could achieve some of the necessary reductions?
So this is Lavelle. So as noted in the response to PA-4, and as noted in the extensive analysis provided in PA-3, the company evaluated the portfolio of solutions that could comprise an alternative to the station. The company has, as you know, a long history with passive and active demand response. And the company has, based on its history and experience, determined that with regard to active demand response, because of the way the programs are constructed, there's a 2 to 4 hour period around which you can call an active demand response. And because historically, data has shown that there is a preconditioning where customers tend to increase the demand prior to being called, and a snapback where the demand naturally increases after active demand has been enacted. The energy tends to increase around those periods. And therefore, active demand response is not necessarily a huge contributor to reducing the peak period, especially given that we've seen the peak shifting to late in the evenings, number one. Number two, the peak is very extensive in that it can be anywhere from 1 p.m. To 9 p.m. And if you look at some of the load curves that have been described and some of the data that has been presented, for active demand response or any alternative to be viable in reducing the peak and reducing the need for the substation, they would have to cover an extensive period of time and be available late in the evenings when the peak is occurring.
Thank you very much, Mr. Freeman. And has the company assessed in detail what those changing load curves would look like as a result of active demand reduction programs?
In PA3, the company has presented load curves that shows the impact of energy efficiency and solar. Active demand response was not one of the contributors in that analysis. I would have to get back with you about whether the company has actually done extensive analysis with active demand response. I don't have that answer at this point.
Can I quickly comment on active demand, just a few sentences?
Absolutely.
So active demand is a voluntary program that would be entered in by our customers. They would have the ability to come and go as they please. So these would be temporary demand reduction measures. These would not be permanent reduction measures. So we need to keep that in mind when we're talking about active demand.
Good point, Dan.
Thank you, Mr. Ludwig and Mr. Freeman. Has Eversource communicated with any of its industrial or commercial customers about active demand management programs?
So I will attempt to answer that question. And so the active demand response, for us to develop an assessment of the impact of active demand response, we would need to develop and design an active demand program specifically for this load pocket. We already have several large customers in this area now. They have participated over the last 3 years in the current program, which runs 2 to 4 hour events. As I mentioned, the peak is so extensive, we'd have to design a program specifically around a 6 to 8 hour active demand event. And we have not done that, and we have not assessed whether or not this is possible.
Thank you. Is it fair to say that Eversource has not fully assessed whether a combination of active demand reduction programs, energy efficiency, distributed generation, and battery storage could achieve some or all of the necessary reductions?
No, I don't think it's fair to say that, because I think the company has done a really good job of looking at what is plausible given the nature of the demand, given the load curve that is inherent in East Boston. The company has presented this in PA3. And if you look at PA3, it looks extensively at what the solar entitlement is historically and what we can project responsibly going forward. It has looked at passive demand, energy efficiency as a reducer of the energy demand. It has looked at battery storage and a combination of these and stacked them up against the need, particularly the locational and the spatially driven need to understand whether active demand or any other components could meet the need. Again, the only component we did not specifically include was active demand response, because we, based on the reasons that I said before, we did not see it as a component that was able to contribute to meeting the need. But all the other elements that you mentioned, battery storage, solar, energy efficiency, they were part of the analysis.
Thank you. And is the company's response to PA3 the complete combination of programs that Eversource has assessed to determine whether there could be an achievement of all or some of the necessary reductions?
PA3 represents the final analysis.
I'm sorry, what represents?
EFSB-PA-3, the response represents Eversource's final analysis of the ability of non-wise alternatives to meet the need. It does not necessarily represent everything that we looked at before determining that these are the most viable technologies, given, for example, the lack of gas in the area. We couldn't responsibly, put forward gas turbines. And so when those were eliminated, PA-3 represents the final analysis of all of the technically viable alternatives, and that can be put forward.
Thank you, Mr. Freeman. I'd like to turn now to the company's response to CLF-GR-N-1. And in the second paragraph of this response, the company indicates that it does not have a mode or method to track the amount of energy used by all customers with any level of granularity. Do you see that?
I'm trying to get to the question. Do you have specific sentence? I'm trying to point to that area, Ms. Rubin. Just 1 second, please.
I will wait. It is in the second paragraph.
Okay. No, the action. The system in place. Okay, I found it. Please go ahead with the question. Thank you.
Okay, I'm just gonna now compare to a different response the company has made. So if you could keep that one close. Please now turn to CLF-GR-N-22.
N-22.
And tell me when you have that pulled up.
Okay. I have it.
Okay.
You got it, one?
I'm in the second paragraph of CLF-GR-N-22. The company states that it has more granular data, such as actual historic Chelsea Station number 488 peak demands, weather, economic, energy efficiency, step loads, and solar, which enable the company to produce reliable, localized forecasts. Is there a discrepancy between the company's response to this information request and the one I just referenced, CLF-GR-N-1?
I need a minute.
I think I can take that one.
Go ahead, Don.
Go ahead, Don.
Alan, did you have a question?
I'm just not sure that I was hearing anybody speak clearly, but we'll go ahead.
Sure, I'll take a first stab at that one. So there's no discrepancy between what the two paragraphs. N22, when we're talking about historical peak demands for station 488, peak demand is measured in total. Right? From a load forecasting perspective, when we're forecasting peak demand, the residential, commercial, industrial aspect, that does not come into play. For peak demand, we look at it strictly in total. Right? The company does not have advanced metering, as is mentioned in N1, which is why that response was written that way. We don't have residential, commercial, industrial demand. We don't have those pieces. What we do have granularity for is the historical actual peak loads in totality for each year for station 488.
And if I can elaborate a little bit on that, this is Mr. Freeman. So the context of N-22 is important because this was contrasting a region-wide ISO analysis to look at regional needs, regional transmission needs, and contrasting that with the need for a distribution station. And the point that the paragraph is trying to make is that the company has more granular information to inform the distribution need as opposed to a regional need using the ISO forecast. And then the scale of the previous question that you mentioned was contrasting between substation level and customer level. So we have different levels. And of course, the company doesn't have granular customer level data, but we do have substation level data, which is granular compared to ISO regional forecasts.
That was very helpful. Thank you both. Let's turn now to the company's response to CLF-GR-N-42. And that is referencing back to the same response we were just discussing. Eversource states that it has not evaluated electric vehicles as an energy storage opportunity and provides several reasons. In part B, again, this is referencing the CLF-GR-N-22. Eversource states that electric vehicles are expected to have only a small impact on load growth. Has Eversource quantified that impact?
So Eversource is in the middle of doing extensive electrification analysis for its stations. We have completed an analysis for the East Cambridge station. And as discussed elsewhere in this docket and in the 22-22 docket, we're intending to complete analysis for our other stations, our other major capacity project stations by the end of 2022. For this docket, the company has looked at what's the right word? At a generic level, I guess, the impact that electric heating conversion and electric vehicle transportation sector conversion would have on our stations. The analysis showed that we are now a summer peaking system. In 20 years or so, we could transition to a winter peaking system driven by electric heating loads as much as 100 megawatts, 100 megawatts of additional demand due to heating conversion. I think the contrast is with electric vehicles. We are seeing the possibility of an additional 8 megawatts in the winter. Every 2,200 or so cars adds about 1 megawatt of unmanaged charge to a single station in East Boston. So at Eagle Station, possibility of 8 megawatts additional in the winter, maybe half that in the summer. So by contrast, electric vehicles should add less to the station demand than electric heating. which is by far the major component of electrification demand.
Thank you. And just to confirm, as part of this analysis that Eversource expects to complete by the end of 2022, will that include vehicle to grid integration, essentially allowing the EV electric vehicles to dispatch electricity into the grid?
We actually addressed this in one of the questions. I don't recall which one. If you give me a second, I can attempt to find where we address specifically this question.
Sure, take your time.
I don't want to miss the crucial points. I'm getting there. So it looks like it was I'm sorry, yes. So CLF-GR-N-41, which is precisely the question you asked. Has the company evaluated electric vehicles as an energy storage opportunity? And there are two issues that I see that will come to play. Now, your question is forward-looking. When we do this analysis, will we consider EV, vehicle to grid, as a component? And at this point, I would not rule it out, but I would like to point out some of the issues that we're seeing with that technology going forward as a load reducer. It's actually a load driver, as Part A states. Electric vehicles are not necessarily a storage solution. They do add to the demand on the grid, and they do add to the demand on the grid during the daytime hours, due to commercial vehicles arriving, and in the evening hours due to vehicle terminations in the evening. So we would expect, based on the analysis, I think that was pretty clear, there to be additional demand due to electric vehicles. Due to the mobility, it brings to question whether they can be reliable as an asset that would provide capacity to the grid, because just the very fact that they move around, the very fact that they have charging requirements, and possibly charging requirements at the time when they're required to provide capacity relief to the grid, it does bring that tension into play, and doubt as to whether they can be reliable as part of the solution, whether in isolation or combination with other technologies. And then on top of that, we have the control and the ability to orchestrate vehicles, and for the company to have control over these, for them to be a reliable alternative to firm station capacity. I think all those are issues that would come into play, and we will certainly look at. But like I said, at this point, we're not willing to rule anything out.
Thank you. I'm not sure I quite heard an answer to my question. For the analyses that you referenced would be completed by the end of 2022, will that include the vehicle to grid analysis?
At this point, I would not rule it out, and I would not rule it in. I am just saying there are issues, and those issues are clearly delineated in CLF-GR-N-41, which could preclude vehicle to grid as being part of the solution.
Thank you. And who would make the determination as to whether that analysis of vehicle to grid technology would be incorporated in the additional analyses that the company is planning to complete by the end of 2022?
It will be part of when we do our analysis, which will include looking at non-wise alternatives for each one of these.
I'm sorry, which will include looking at what?
When we do the analysis of the electrification demand and the ability to meet that demand, that analysis will include a non-wise alternative NWA assessment, just as we've done for East Cambridge. That would look at all options. And as part of that analysis, we will look at vehicle to grid, and we will look at it on its merits.
Okay, and would that be your team, Mr. Freeman, who would make the decision to consider that part of the analysis?
Yes, that would be my team. But again, I would like to emphasize that just as our analysis in PA3 has looked at storage, just storage, even central located storage or dispersed storage, and there are issues with the reliability of storage to meet the need, electric vehicles adds even another dimension of unreliability, just because of its mobility and because of the multi-use. It's being used for different purpose rather than providing capacity grid. It's being used for transportation. So I'll just keep that in mind. Not optimistic.
Thank you. You have referenced several times the company's response to EFSB-PA-3. When you're considering photovoltaics, do you combine the photovoltaics with energy storage systems?
We did look at the combination of battery storage and photovoltaics.
And is the information provided in that response the complete set of information relevant to this topic?
This, along with the response to, I think it's EFSB PA- I want to say 5. Let me just make sure, yes. So I would say EFSB PA-3 along with EFSB PA-5 provides a complete record of our analysis.
Thank you. Does Eversource think that the electric vehicle technology will continue to evolve even within the company's 10-year planning horizon?
Absolutely. Technology is not standing still. It will continue to evolve. And the company is, as you know, the company does have an interest in electric vehicle in terms of accommodated vehicles and vehicle infrastructure, electric vehicle charging infrastructure. And there's a whole group that looks at this and prepares for the advancements in technology and the impact that we would have on our systems.
Yes, thank you. Is it fair to say that Eversource has attempted to quantify the impacts of electric vehicles will have on growing the load, a source of electrification, but has not attempted to quantify the impacts of electric vehicles on reducing the load as a source of energy storage capacity?
It would be correct to say that the company has looked at the impact of electric vehicles on increasing the demand. The company has looked at the ability of energy storage in all forms to reduce the need for capacity build out. And that's clearly demonstrated in our analysis in EFSB PA3 and PA5. Electric vehicle is just another means of energy storage. And I think the analysis that we've done for energy storage in those responses also apply to electric vehicles as storage.
Thank you. And the storage.
Excuse me, Ms. Rubin. I should add to that answer, Lavelle. So, as the manager for distribution system planning in this area, right? I should expand on the answer to say that these types of solutions, including electric vehicles, right? They're very random, right? As for planning purposes, for design purposes, this is not something we can consider a firm capacity. So, to summarize, electric vehicles as a source or even storage and even solar, they will not replace the proposed solution. because they do not provide a source of firm capacity, and they do not provide the same reliability as the proposed solution. And I'll expand a little bit on that too, right? So when you talk of non-wire solutions, the company position is that there should be a certain level of reliability already that we can complement the non-wires with, right? The challenge with the electric service supplying East Boston is that is not there. We're not at that level of reliability that is similar to other on-the-ground electric areas in the city. So even a combination, and we've already stated that in a few of the information requests, even a combination of this non-wire solution will not eliminate the need for the proposed solution, because the proposed solution is comprehensive. It basically deloads one station, brings transmission supply to the East Boston community, brings a transformation source, and it provides a significant reliability improvement to the distribution line that supply East Boston. So I think this question you've asked a few times, but in general, I just want to say, even a combination of non-wire such as this will not replace the proposed solution. Thank you.
Thank you. And you both, Mr. Freeman and Mr. Martinez, have mentioned storage options. Is that referencing centralized storage or distributed energy storage systems, or both?
Both. We've looked at both centralized and distributed energy storage systems, and they suffer from some of the same drawbacks that Mr. Martinez mentioned. There are reliability drawbacks, there are dependability drawbacks, and there are drawbacks in terms of being able to charge and being able to reliably charge the storage systems within the substation rating demands, substation rating requirements, as again, PA3 clearly shows, and being able to respond to a multi-day event and being able to have headroom for growth. So all these are drawbacks of storage, whether they be dispersed storage or centralized storage. And
I'm sorry, dispersed storage or what?
Or centralized storage. And they have been shown clearly not to be viable alternatives to the proposed station.
And I should also expand on this one, Ms. Rubin. So storage doesn't basically remove load, right? Storage basically doesn't reduce load. It actually just shifts the time when the load is there, right? So back to my original answer saying, there has to be a certain level of reliability already in the system in order to integrate non-wire. So if you think of the electric system supplying the East Boston community, and we've addressed this in EFSB N6, I believe. If you think in the current way the electric distribution system is configured, the residents of East Boston are supplied from a substation that is in Chelsea. Distribution lines come out of that station and they basically run through Chelsea. They go down the creek and then they arrive at East Boston, and then those lines now sparse over East Boston. They run along the East Boston area, right? So when you think of storage is only shifting when the demand is being when the battery is being charged. So those are the same distribution lines that will have to provide the storage charging, right? So the same distribution lines that come from Chelsea down the Chelsea from Chelsea substation, down the Chelsea area, down the creek, up the creek, and then along the East Boston communities are the same lines that this non-wires alternative will be relying on to charge the storage and then discharge it at different times. So again, back to my original answer, there has to be a certain level of reliability already that we can complement with non-wires alternative.
Yep, and on top of that, the same station that is right now thermally constrained would be required to charge the storage device. And so you are not reducing the load on the station because you're adding yet another device that would draw from the station and increase the demand during certain times of the day.
Given that the company sees no viable alternative to the proposed substation, is it fair to say that the siting board has two options: to approve the proposed substation as proposed for East Eagle Street, or allow outages to begin in East Boston?
I cannot speak to what the siting board's decision matrix is, but I can tell you that based on Eversource's analysis, based on Eversource's experience, this station is needed for reliable supply in East Boston for our planning horizon now, and is a critical element of the future supply in East Boston and Chelsea. Because don't forget, this station would be able to effectively manage the load on the Chelsea and East Eagle Station working together would be able to effectively balance and manage the load, back each other up, provide reliable supply, not just for East Boston, but for Chelsea, both stations working together. But there are critical elements of the future supply in the state. If the state is going to enact and achieve its decarbonization goals. So that is all that Eversource is saying today. This station is needed for reliability in East Boston. It's needed for the future of the electrification goals for the citizens of East Boston. And whether or not the siting board has a choice around this, I think that's a question that I would not address.
Well, and I would just add that if the station doesn't get approved, and we certainly hope it does, because just as Mr. Freeman said, I mean, it's critically needed. We'll certainly do the best we can to keep power on in East Boston and Chelsea. And, that may mean, things like generators that, those aren't very popular in this area either, but we'll do, absolutely the best we can to keep our customers' power on, either, constantly or in high heat periods, some kind of, rolling type blackout situation until some other, plan is, obviously we can't just leave this area unattended. Something has to give. Our position is this is the best solution, but if it doesn't get approved, we're gonna do as best we can to keep the lights on. But my concern is that that's just asking for trouble, because there isn't a lot of options left. And even generators, has limitations. And then, as I said before, one of the most serious things that we could find ourselves is running this equipment at station 488, harder and harder and harder. And I think we all know when you run machines at their upper limits, you're asking for trouble. And if we do something that negatively impacts 488, specifically the transformers, we're in a very, very bad situation.
I wonder if we might take a break sometime soon.
Stacy, is this a good time to take a break? Short break?
Happy to take a break, and I only have a few more questions when we come back.
Okay. So why don't we take a 15-minute break, Alan?
Thank you.
And we'll be back at 5 of 4. back on the record. Stacy, do you have some more questions?
I do.
Thank you.
I think I will be done before the end of the day, certainly.
Thank you.
Has the company discussed when rolling blackouts could begin in East Boston?
I should probably take that question, Ms. Rubin. So the company definitely doesn't design or operate its system with rolling blackouts in mind, right? But what we have stated in the documentation is that by 2025, we will have reached the emergency capacity of the substation based on our current forecast. And when that happens, you know, we have no other alternatives. We have no basically, we don't have another source of supply. When that happens, we have very limited emergency options, right? And I think Mr. Hallstrom mentioned earlier that, you know, we will definitely take all the precautions we can, and we'll definitely do all the potential emergency mitigations that we can, temporary emergency mitigation. But I think the point that should be highlighted is by 2025, the substation will reach its emergency capacity. And by then, we basically have no, we have no solution other than very limited emergency options. And when those are exhausted, right, then you know, the only available option is rolling blackouts. But the year is 2025 when the substation firm capacity, the station emergency capacity will be reached based on the current forecast, which again is our forecast, and it could change, right? So earlier on, you actually address the step loads that are in our forecast. Again, that step load is based on what we have right now. So we have confirmed load letters, let's say from Hertz, you even mentioned it earlier. So we have confirmed load letters from Hertz that are in the forecast, and we put it in there. But, you know, in the chance that maybe other companies decide to electrify their fleet, that is currently not in the forecast. So that 2025, that could shift earlier, but based on the current forecast, based on the station capacity, 2025 is when we do not have excess emergency capacity.
Thank you, Mr. Martinez. The emergency capacity that you're talking about, or excuse me, the temporary emergency mitigation that you referenced just now, have you discussed those measures with representatives from the city of Chelsea?
I personally have not, but I think we've mentioned that in.
I can take
Okay,
this,
go ahead.
as well as Ms. Bowden and Mr. Hallstrom. Yes, we have communicated the measures that we would likely need to start taking this summer in Chelsea and East Boston, given how we are currently running the system.
And can you, Ms. Engstrom, can you characterize what those conversations have been?
Sure. I'm going to defer to Ms. Bowden and Mr. Hallstrom, who spoke with the city of Chelsea. I was not.
I'm sorry, Ms. Engstrom, can you start over? A word got cut off.
I'm going to defer to Ms. Bowden and Mr. Hallstrom. I was not at the Chelsea meeting, but the two of them were, so they can elaborate on the Chelsea discussion.
Absolutely. Thank you, Ms. Engstrom. Can you just repeat the question for me, please, Ms. Rubin?
Yes, the limited emergency options for temporary emergency mitigation that you have discussed with the city of Chelsea. Could you describe and characterize those conversations?
Yes, we've spoken with them on several occasions now, and those conversations, although they understand the need for a temporary solution, they would prefer not to have the temporary solutions as we've stated in the city of Chelsea, they do understand that there's a risk to electricity in both the city of Chelsea and East Boston. They are hoping that the substation is constructed so we can mitigate that risk, but at this time they do not want to see mobile diesel generators in the city of Chelsea. Craig, if you want to just elaborate more on those conversations.
Yes. So we met with the city and a number of people, including the city manager, and we're very clear about the plan, the risk. We have a piece of property. Eversource has a piece of property that's electrically tied to Station 488, and we requested the ability over the summer just to park generators there, if in case we needed them, because that would be the solution. If we lost a transformer, if we had an issue, or there was an extreme heat wave this summer, that is the only issue to keep the lights going. And the city was adamant. They didn't want us to just even park the generators on that piece of property that we own. And and after the meeting, I talked to the city manager and said, I'll do the best I can, and we'll work as fast as we can. And we're not going to fight the city on this. It's their call. That's the way it was left. I can tell you, Eversource, my team, my group, we have a plan in place on exactly what we will do on that piece of property if the lights go off. And my guess is people will want us to do it at that point.
Just add that what we were asking the city of Chelsea to do was to, as Craig said, put the generators there ahead of time. They would not be on, they would simply just be parked at our own location to help mitigate the overall impact that these customers would experience should their lights go out. If their lights do go out, Craig, we would ultimately still use these generators to help get that power back on.
And the benefit of having them there in place, it would mitigate the lights from ever going out. So we would get to a point, our equipment would go, either enter emergency or approach emergency, and we would put the generators in service to prevent the lights going out at all. But that plan wasn't well accepted.
I will say, Ms. Rubin, that although that plan wasn't a favorite for the city of Chelsea, I've been in communication with folks at Chelsea as a community relations rep, and we continue to have mutual respectful relationships with one another. Although we did not agree on the mobile diesel generators during that initial conversation.
Thank you. And just to confirm, what is the status of the diesel generators in Chelsea?
They're not going to be delivered to Chelsea. Like I say, I have a plan. My team has a plan if we need the generators, and if we do have an issue, or if we do have an extreme heat wave, we will take steps to probably bring them onto make sure they're available. We don't own the generators. We have a contractor who provides the generators. But right now they're not on Chelsea property.
And who owns the generators?
A company called Sunbelt. They're a vendor of ours. We use generators, a lot. They're a vendor of ours. They serve us very well. But this is not it's not a one-off per se. Maybe the size is different, but we use generators a lot to keep our customers going during maintenance and those types of things.
What is the fuel used to power such generators?
These ones, they are diesel. Half of them were, and I'm probably way out of my space, but we really look to get low emissions units in place, and we were able to get about half of those as low emissions.
And what are there generators powered by non-fossil fuels available?
Again, not to my knowledge, no. We looked into, gas generators, but at this size and this application, they really don't exist. They're traditionally diesel generators, and it's a matter of what type they are in terms of how much emissions they produce.
Thank you. How can a third party assess whether the company needs to begin these rolling blackouts?
Well, a third party doesn't assess it. Eversource assesses that. A generator is just a tool to us that we put in place when we feel there's a need.
It sounds like the reaction from the City of Chelsea officials was skepticism at best. If Eversource is the only entity to evaluate whether the company needs to begin the outages, how can the City of Chelsea or others trust that that is actually the need?
Well, I guess I would say in this case, the lights would be out, so there would be a need. And I would also like to add that we use these diesel generators every day. Different parts of the Commonwealth, different parts of our operating territory across Connecticut and New Hampshire. When the lights go out, it's our responsibility to get the lights back up. That means in interim, we use these mobile diesel generators. We do. We have sections of the city that are clamming for them anytime there's any kind of work done. They don't want to be without power even for 1 minute. It is a source that allows people to continue with their day.
I'm sorry. It is a source that what?
That allows the community to continue with their normal day-to-day operations, including things like we're doing here, being able to have a Zoom meeting, if the power were to go out.
And I would add, when we met with the city, and it was a very cordial meeting. I mean, I don't think their issue was questioning whether we, Eversource, knew when to turn them on or off, by the load. And then, I would think, I would say that, if there was a prolonged high heat period, ISO New England would be another source of information, so to speak. But I don't think there was a question by the leadership in Chelsea that we didn't know what we were doing in terms of when to turn the generators on.
You're absolutely right, Craig. The issue that they're facing is that this substation has taken so long to site and permit that we've now gotten to a point where we need to enter into emergency measures. And so they are upset that at this 9th hour, the substation has not been constructed, and we now need to put Chelsea in a situation where generators need to be ran in that community. And so they are looking to get to the final resolution, which would allow their residents to have equal working electricity in Chelsea.
Thank you. And I'm aware that we don't have people testifying from the City of Chelsea in this proceeding, representing the city officially. I'd like to ask the same series of questions with respect to officials from the City of Boston. Has the company discussed when outages could begin in East Boston with City of Boston officials?
We have not had the same formal conversation with the City of Boston, as the mobile diesel generators were going to be housed in the City of Chelsea. We don't really have, and Craig, correct me if I'm wrong, a place that we had similar to Chelsea where we own this parcel of land that we could have stored these mobile diesel generators. And that's why the conversation began with the City of Chelsea.
Sorry, and that's why the conversation what?
Began with the City of Chelsea.
The reason why the City of Chelsea was the area is because, like I say, we own a parcel of property very close to Station 488 that used to have a substation on it. And the underground infrastructure that connects those two pieces of property are still in existence. So the most efficient and effective use to use generators and minimize how many you would need is to put them in the one location, bring underground cables over to Station 488, and attach right to the substation. So you get the biggest bang for the buck from the generator directly into the station, and then it gets distributed out, across the area.
Thank you. When the company first filed its its petition in 2014, did the company state that the reason for the substation was to prevent rolling blackouts?
David, can you chime in on that?
Well, it's a factual question. I think there's a big record in the 2014 case. We certainly indicated that the facility was needed. I'm not in a position to recall or to confirm Stacy's question of whether the basis for that was on rolling blackouts.
Can you repeat the question? I'm sorry.
Yes, in 2014, when the company initially filed its petition for approval of the substation in East Boston, was one of the reasons cited to prevent rolling blackouts?
So I don't know if that was written in the document necessarily. Rolling blackouts is just an outcome. An outcome could be, an outcome to not have capacity when you need it. Another outcome could be we can't hook up any more customers. Another outcome, so the rolling blackouts is just an outcome of not having enough capacity to serve customers. The need is we need another substation to provide reliability, resiliency, and also future development, electrification. So
I would also add, Craig, that in 2014, the company did not anticipate we would be going through this many years of litigation. And so, I don't know if that was in that filing, but we expected to have the substation constructed and in service by 2022 or way before as well.
Right. So it's an outcome, just like use of generators is an outcome. So.
Is it fair to say that for the last couple of years, the company has been concerned about the outcome of rolling blackouts because the substation is not constructed and operating?
Well, again, we're concerned we're going to run out of capacity to serve. And again, the blackouts are an outcome. Like I say, our general concern or our primary concern is that we're not going to have enough capacity to serve. I mean, my concern too, as I said previously, that the harder you run these substations and the harder you run the machines in the substations, the more risk you put on the single substation. So, the rolling blackouts is just, like I said, keep saying it's an outcome. What I keep saying, I'll go back to the broken record comment, is we need another substation. The load is exceeding what we can serve.
Thank you. And has there been a rolling blackout in East Boston in the last 8 years?
There hasn't. There has not.
Has there been a rolling blackout in the city of Chelsea in the last 8 years?
Well, subject to check. I don't think we've had an issue. So if there was one in East Boston, there'd probably be one in Chelsea. We only have one substation. So in the last 8 years, I do not recall any catastrophic failure at the station that would cause that. But again,
Correct.
Yeah.
Yeah, I should probably expand on that. So under EFSB N7, we actually provided a comprehensive list of outages and substation events in Chelsea substation since I believe it was 2017. So all that is in record. What I will be a little careful on is defining blackout, Ms. Rubin. So we've purposely, or the system has purposely not tripped, or we purposely have not tripped customers out during peak load days because we've reached capacity as an event of N-1 or an outage at the substation. Purposely, I mean, and that's, let's define, if we define rolling blackout that way, then no, but we have had outages in Chelsea Station 488, and the list of outages are listed in EFSB N7.
Thank you. And I'm going to go back to a very old document since all of the materials from the underlying records are part of this record. I'm going to go to from the project change filing in EFSB 14-04A. And I'm going to go to information request GR-ESRN-3. And this was filed by the company on May 21st, 2019.
Just Stacy, just so we're clear, that was an information request propounded by Green Roots in the project change proceeding?
Correct. Is it appropriate for me to put a link to the file room in the chat, or is that not okay?
I have no problem with it. I'll leave it up to Ms. Sharkey.
No, I think that probably would aid people actually seeing the document, so we'd appreciate that.
Okay, I'm putting into the chat a link to the document on the online file room.
I haven't located that document yet, but I will, if I recall correctly, that document, although part of the administrative record, is not part of the evidentiary record.
I thought I had asked this question in our first hearing day on May 17th, and I thought the answer was that all of the information filed in the underlying two proceedings were part of the evidentiary record in EFSB 22-01.
Just to be more precise, those discovery questions were subject to a motion to strike by the company because it was an attempt to relitigate the need issue by Green Roots. We provided information in response to those, subject to our objection that it was outside the scope of the project change proceeding. And that motion to strike was granted by the hearing officer. So the document was retained as part of the administrative record, but it was not part of the evidentiary record on which the citing board made its decision in the project change proceeding. I'm not trying to split hairs, so it is in the record, but it was not part of the factual record on which the project change decision was made.
I'm going to re-ask the question since need is a part of this current proceeding, but if it's better to do this as a record request, the witnesses will let me know that. So I'm essentially wanting to understand if since we've just established that there have not been rolling blackouts subject to Mr. Martinez's clarification of what we mean by blackouts, I want to talk about several residential and commercial facilities that have been built in Chelsea and East Boston over the last several years. So my question is, has the residential development One Blossom in Chelsea been constructed?
I can probably take, the answer is yes, Ms. Rubin, but I believe we provide a record of the installations in EFSB N6 and which ones we have as all expected loads in service date. So they're on EFSB N6, specifically table EFSB N6.2, EFSB N6.2. So referring to that table, One Blossom Residential, we have it as all as in service, correct?
Thank you. And 28 New Street in East Boston?
That is also in service, referencing EFSB N6.2.
How about the Federal Bureau of Investigation facility in Chelsea?
I think the FBI building is also in service. That's correct.
Excellent. And this older information request, this from the project change filing, references Massport Logan Airport proposed development of new 10 MVA major customer project. Has that been constructed?
Yes.
Thank you. And do these 4 different projects result in an increase of 135 MVA demand?
So this is probably where I have to bring table EFSB N62 again, because we do provide what we expected or what we saw as the percent in service. So maybe this is a good time to reiterate that when we did this submittal in 2019, we did it with the best information that we have on hand, right? So we list, and again, we have a process that was listed in the EFSB N6 submit N6 that lists the process of gathering information from customers. So this is a good time to point out that we do that with the best information we had on time, and that information could change. So customers' plans, customers, they come to us with, let's say, a load letter, and some of those plans could change. And we do have examples of those even in here. Like the FBI building is one example where they came to us and they have a specific design in mind. So that, you know, and then that changed right through the middle of their submittal. And that was a little lower actually than expected. And it's just a matter of we use the best information we have on hand and then it changed. So to say that it's 135, I think I'll have to review what was in EFSB N6 and kind of compare them. But the simple answer is all the answers are actually in EFSB N6. So that will give you a good detail on what we expect the load actually materialize to.
Thank you, Mr. Martinez. How did the forecast of demand that was done back in 2019 for the project change filing match the actuals that the company has access to now?
I'm also going to point out, and I mean, I'll defer to Dan on that, but I will point out that we did provide extensive information on EFSB N6 on all the changes from when we submitted, you know, the 2019 till now. So the information is there. And maybe Dan can expand a little bit on that if you can repeat the question. So for him.
Yeah, if you don't mind repeating, please.
Yes. How did the forecast of demand that was conducted for the project change proceeding match the actuals that the company has access to now?
If you could just give me 1 second to find the forecasting accuracy exhibit we put together.
Of course.
Okay, so the 2019 forecast on a weather adjusted basis, our forecasting accuracy has been around 4% for that station. I mean, for that 2019's forecast.
Thank you. And can you just explain to those of us who are not engineers what a 4% accuracy means?
What a 4% accuracy means. So I guess here what we're comparing is to what actually happened, and then we're comparing that on a weather adjusted basis. So we adjusted the actuals to what would have occurred if a 90-10 weather event occurred, and then we're comparing that to our forecast. You know, we don't have a percent target we're trying to hit. Every time we do a forecast, we're always trying to be as accurate as possible. That is always our intention. And each year, we update our forecast. Right? So our goal is to always be as accurate as possible at 0%. That's our goal. In this case, we're at 4%. We feel we're pretty comfortable with that. It's not it's within a range of reasonable outcomes for us. But as we've stepped through time, our forecasting accuracy actually over the last 6 cycles has actually steadily increased. So we've been between 3 and 4, and in the last 2 years, we're actually around 2 to 1% in our accuracy.
Thank you very much. I don't have further questions at this time.
Thank you, Ms. Rubin. Do any of the other interveners have questions, Mr. O'Brien?
Yes, we do have a few, and we're mindful of the hour, but we'll, if I may, just run through them relatively quickly.
And you may, I just want to note sort of a provisional objection so that you're thinking about it as you're asking the questions. Insofar as the Boston Residents Group, their intervention is limited to damage to the environment under the statutory sections of Chapter 30A, Section 10A. We would likely have objections if your questions went to the need for the facility, which is separate and apart from damage to the environment. So I'm not asking for a ruling here, but I'm really just doing this as a sort of advance, not warning, but advance information to you that we would probably have objections to questions that you may pose on need issues.
Yeah, fair enough. And so let me ask the questions and we'll see where we go. And this goes back to the last session. There's just a couple that were raised. So one of the company representatives made reference to an East Cambridge detailed analysis. We'd like to request that detailed analysis. Well, before I ask that, can the company briefly, very briefly describe what a detailed analysis consists of for East Cambridge?
And you're talking about here, Mr. O'Brien, on the detailed analysis that was described regarding project alternatives and electrification. Is that the detailed analysis?
I believe so. It was referred to, it was a report, a company document referred to as a detailed analysis for East Cambridge.
All right, I was trying to determine the scope of your question better so that I would know whether I should be objecting or not. Because there's also detailed analysis the company has done on environmental impacts for a project in East Cambridge, and certainly, and I guess I have to say, if your question has to do underlies issues of need or alternatives, we would object. It's outside the scope, we believe, of the intervention that was granted to your party.
No, I appreciate that. I mean, we do believe there's a thread of argument that would lead back to the environmental damage under which we're working here. But let me put it this way to keep things sort of on focus. At the last session regarding need, the company made reference to what I believe was entitled, a document entitled A Detailed Analysis of East Cambridge. And at the same time, a statement was made that a similar detailed analysis had not been completed for East Boston. And so, to keep it real simple, we would like to have an information request. If there is indeed a document entitled Detailed Analysis for East Cambridge, we would like to see the copy of that, so we know what East Cambridge benefited from, but not East Boston.
Well, I don't know how this gets around my objection. In my understanding of the scope of your proper inquiry as a party here under 30A, Section 10A. So I would ask the hearing officer for clarification of that at this point.
Yeah, look, if I may just very briefly, I can address it. There may be things in the detailed analysis that have relevance to environmental damage.
I wonder if we could find out what is the quote unquote detailed analysis that was referenced in the last hearing so we know what document we're talking about?
Perhaps Mr. Freeman or Mr. Martinez could answer that to help resolve the question.
Yeah, so I'll begin. So the detailed analysis was meant to look at the electrification impacts in East Cambridge beyond the planning horizon. This required us to develop a very detailed model of the East Cambridge electric power system in our distribution planning tool, to execute a time sequential analysis, to look at the forecasts of EV, of DER, of electric heating conversion. I'm sorry, strike that, not the forecast, but the projection of these as aligned with the state's decarbonization plan, and understanding what these impacts of demand would do to the station, the detailed station model that we've developed, and then understand what the reinforcements would be needed to accommodate the electrification impacts, or to understand if reinforcements that are driven by the needs in the planning horizon would also accommodate future electrification. Does that help?
Mr. Freeman, is this something that was provided in the company's filing in EFSB 2203?
No, I think this was, sorry, one guy, this was filed in 22-22 rate case, correct?
So the detailed analysis, it's referring
for East
to
Cambridge.
Yeah, for East Cambridge, it's referring to demand capacity. I mean, I'm saying not necessarily to environmental, but it was filed with the East Cambridge petition, the EFSB petition. We can actually find the document, and the analysis is there, but it's not related to environmental. It's related to capacity and capacity need at the substation, and capacity need of the new substation.
And reliability.
Correct.
So, Mr. O'Brien, what I'm going to say is that I believe from the description of the analysis that asking questions on it is outside the scope of your proper inquiry, given the delineation of what you're allowed to address in under the 10A petition that we allowed. However, they've also told you that it's a public document that you can find on the siting board website.
Yes, thank you. We don't object to that. That makes sense for us. My ears perked up when they said East Cambridge got an analysis, East Boston didn't. So there may be some disparate information or treatment there that of concern. But we'll look at the document and see if it's relevant and provide it in subsequent pleadings, whatever. But thank you for that. Two other quick thoughts here. In the prior discussion a couple of weeks ago, the company used the image of an island, that East Boston is a sort of an energy island because it's served by over from Chelsea. And as a analogy to that, talked about the Martha's Vineyard reliability project. And so the question, we have two questions. The first is, since the company introduced it, the point of the analogy to Martha's Vineyard, our question is, where are the substations serving Martha's Vineyard and Falmouth located relative to the cable crossing, basically?
Yeah,
Go
ahead, Mr. Blue.
Sorry, Juan. I would renew the objection. I think also there's a question of relevance, although they did testify as to location of those substations and the ability of them to be backing up one another. But again, that dealt with reliability issues, capacity issues, reliability issues. It didn't deal with environmental impact issues, or more particularly damage to the environment, which is where your sweet spot is for participating in this proceeding.
In terms of relevance, the company introduced it, not us. But the second question I have on this is that, does the company agree, or does the company understand that whether or not Martha's Vineyard or Falmouth are environmental justice designated by the state of Massachusetts?
Are they environmental justice communities, is
Yes.
what you're asking?
That's the question, yes.
I can say to you for siting board purposes, Mr. O'Brien, that we look at the proposed facility and the location of noticed alternatives and determine the proximity of environmental justice neighborhoods in connection with the locations of individual projects.
Thank you. Yes. So this is the last question. It sort of picks up a thread from earlier of today, and that was sort of the Plan B question. Does the company have in place an option alternative to provide reliable electric service to Chelsea and East Boston should the pending Supreme Judicial Court decision be adverse, or for any other reason that this substation cannot be built?
Did you ask that question this morning, or was that Ms. Rubin?
Well, I asked it, but it was then deferred to the need portion.
Yeah, okay. So in deferring it to the need portion, I didn't mean for you to step into a trap here where I could now object to the question because it's a need related question. But in fact, that is the case. The question is one of need and how the company would ensure reliable service in the event of that hypothetical you described. And as such, I believe it's outside the scope of your intervention.
I would agree, Mr. Rosenzweig. I'd also mention, though, Mr. O'Brien, that you have been present, for example, for the questions that Ms. Rubin has been asking with regard to reliability and company options in the face of potential changing needs in the East Boston and Chelsea areas. So you have the advantage of receiving information related to those questions, even though those are not strictly speaking topics that you can raise within the scope of your intervention.
Yes, I do agree. I think that, and this will be a very brief statement, the question of options is a central one in this proceeding. What are the consequences of approval? What are the consequences of denial? What are the consequences of some other action, a stay perhaps? There is a thread of argument that leads to things that are within our kind of reach, that is environmental things, in terms of trading off options. So it's a logical progression. The option question was begun with things like pre-staging diesel generators and so forth, but I don't think it was fully thought through in terms of what's down the road. But I'll leave it there, and thank you for those clarifications and responses.
I'm assuming Mr. Hopper doesn't have any questions for the witnesses.
Thank you, Ms. Sharkey. That is correct. Good afternoon to everybody.
Thank you. Well, if there are no other intervener questions, we are scheduled to resume on Wednesday with staff questions for the need panel. Unfortunately, we're scheduled for the full day of that on Wednesday. So if there are no further matters to be addressed today, I propose we conclude the hearing today and resume at 10 o'clock on Wednesday.
Thank you.
Thank you, everybody.
Thank you.
Thank you.
Thank you
very much.
Thank you.
See you Wednesday morning. Off the record.